Hello. Hi, Christina, Teresia, can you hear me?
Yes,
Can
I
you
can hear
mute
you.
and
I
tell
can hear
me,
you.
please, if you can hear me? That's Laura.
Yes, good afternoon, Laura and Teresia.
Good
Amazing.
afternoon, Christina
Thank you very much
and Laura.
for
Yes.
being here. So we are waiting for the participants to come back from the lunch, and we will start.
Thank
We can
you.
see you on the screen, and it's perfect clear. So the connection is good with us today. So great. I'm really happy to see you. Thank you.
Thank you.
Please, can you say a word so we see if we can hear you? Yeah, you're both muted. Can you unmute
Oh,
and please?
oh, you're speaking to us again. Okay, yes. I can hear you very clearly. I can see Teresia. I can put on my
Amazing.
camera.
And is the translation
Can,
working? Because I'm gonna speak in French. So is the translation working? I'm gonna try. Bonjour, comment
Okay,
allez-vous?
no.
I can't hear the English part.
Mm-mm.
So, yes, I cannot hear it.
I
Maybe you
cannot
can
hear.
try again. Yeah.
Ah, sorry, the interpreters are not in the room yet. So that's the reason. They,
Okay.
we thought they were in the room,
Okay.
but they are not. They are still in the lunch. So they are
Okay,
coming,
Okay.
but it should be
okay.
fine. You should receive the interpretation.
Thank
Okay.
you.
Thank you very much. We will be two speakers speaking in French, and Patricia will speak in English, and you both will be speaking in English, and we will have both, actually the three translation, Arabic, French, and English. I hope it will be working. So don't hesitate to interrupt if it doesn't. Thank you. I can't see either. I check. Okay. Christina and Theresia, I think the interpreters are back in the room, so we're gonna try the interpretation to be sure that you can have the interpretation on the Zoom.
Okay.
Thank you very much. So, I'll be speaking in French. Bonjour et bienvenue à tous. Est-ce que vous recevez l'interprétation?
Yes, I heard that. Christina? I heard that.
You heard the English translation?
Christina, I heard the English translation. You didn't hear it?
Okay.
Switch
No, maybe I'm supposed to enable
You're
something.
supposed to go. Yes, there is somewhere you're supposed to enable. I can't. I think there is a place where I don't know what that button says, but there's a button about language where it has English, French.
There is a button interpretation, and you need to switch to English, so you receive
on your screen. I don't know if you have the place where it says show captions.
I have tried that. I have clicked. Can we try again?
Okay.
Okay, I try again. Bonjour à toutes et tous, bienvenue dans cette session. Est-ce que vous m'entendez bien en français, en anglais?
Yes,
yes,
yes, I can now hear English.
That's perfect. Thank you.
Thank
That's
you.
all right. So we're gonna start. We can start.
Okay.
Thank you, Theresia.
Thank you.
So we're gonna start.
Okay.
So good afternoon and welcome. Bon après-midi et bienvenue à toutes et tous. Je suis ravie de vous retrouver pour cette session plénière consacrée à la justice centrée sur les enfants. J'espère que vous avez eu un bon déjeuner. Vous avez pu déjà pleinement participer aux sessions qui font la richesse de ce forum. Permettez-moi tout d'abord de me présenter. Laura Jacques, je suis la responsable du programme Accès à la justice pour l'Afrique de Terre des Hommes Lausanne. Et c'est un immense honneur pour moi de vous accueillir et d'animer cette session entourée d'expertes incroyables. Donc avant tout, j'aimerais encore remercier l'Alliance africaine pour avoir créé cet espace de réflexion intergénérationnelle et surtout pour la présence de nos partenaires, nos intervenantes et puis de vous qui êtes ici avec nous en présence, sur place et également en ligne. Donc pour nourrir cette réflexion, nous avons le privilège d'accueillir un panel de profils divers. Et c'est pour moi un grand honneur de vous les présenter, car ce sont des femmes, jeunes et adultes, pour lesquelles j'ai une profonde admiration. Nous avons aujourd'hui donc avec nous en présentiel l'honorable Hermine Kambo Takam Gatsing, membre du comité africain d'experts sur les droits et le bien-être des enfants. Nous avons Madame Patricia Peace Ijang, jeune leader pour la justice. Et nous avons ici en ligne avec nous l'honorable juge Theresia Mateka, juge à la Haute Cour du Kenya et présidente du Conseil national pour l'administration de la justice, de NCAJ au Kenya. Et enfin, Madame Christina Namdo, première commissaire pour les enfants de la province du Western Cape en Afrique du Sud. Nous aurons également la chance et le plaisir d'entendre Imi. Imi est une jeune défenseure des droits de l'enfant à travers un message vidéo qu'elle a préparé spécialement pour la session aujourd'hui. Alors, je vous présenterai plus en détail au fil de nos discussions, mais je voudrais déjà vous remercier pour avoir accepté notre invitation. Et puis, vos parcours, vos engagements sont vraiment une véritable source d'inspiration pour nous. Et je pense que c'est une unique opportunité de cette session pour imaginer des nouvelles voies de changement, d'action, pour renforcer des systèmes de justice adaptés pour les enfants. Donc, avant de donner la parole à nos intervenantes, permettez-moi de poser brièvement le cadre de cette session. Pourquoi parler aujourd'hui d'une justice centrée sur les enfants? Eh bien, parce que bien que les enfants représentent près de la moitié de la population africaine, les systèmes judiciaires, eux, ont été pour la plupart pensés par et pour les adultes. Et dans certains pays, moins de 1% du budget de la justice est consacré à la justice pour enfants. Donc, quand nous parlons de justice centrée sur les enfants, nous parlons donc pas seulement de justice pour les enfants, mais d'une justice avec les enfants. Une justice qui reconnaît chaque enfant comme titulaire de droit, comme acteur de son propre parcours judiciaire, doté de capacités d'action et non simple bénéficiaire de protection. Cela implique donc de concevoir des systèmes de justice qui sont pensés autour de leurs droits, de leur vécu, de leur expérience, de leur intérêt supérieur, mais aussi de garantir que leur voix soit entendue, qu'elle soit consultée et qu'elle soit prise en compte dans chacune de nos décisions de justice qui les concernent. Ceci n'est pas un privilège ni un slogan, c'est un droit. En juin 2025, un signal fort a été lancé avec l'adoption de la déclaration globale pour la promotion d'une justice centrée sur les enfants, portée par les enfants eux-mêmes. Et de son côté, l'agenda 2040 de l'Union africaine pour les enfants d'Afrique réaffirme cette vision. Chaque enfant africain doit pouvoir bénéficier d'un système de justice pénale spécifique, fondé sur ses droits, sur l'intérêt supérieur, mais également sur la réhabilitation et la réintégration, où la détention n'est plus la réponse par défaut. Pourtant, la réalité des enfants en conflit avec la loi sur le continent, elle reste préoccupante. Pour ne vous donner qu'un chiffre, 8 enfants sur 100 000 enfants continuent d'être détenus en Afrique de l'Ouest et en Afrique centrale d'après UNICEF. La plupart du temps dans des centres de détention qui ne sont pas adaptés, qui sont la plupart du temps des établissements pour adultes et dans des conditions contraires à leurs droits et à leur dignité. Ces effets, les effets de la détention, ils ont été bien documentés par les diverses recherches qui ont été produites ces dernières années. Exposition à la violence, perturbation du développement cognitif, aggravation des troubles mentaux, rupture familiale ou encore déscolarisation. Ces approches punitives sont non seulement inefficaces, elles l'ont été démontrées, mais en plus elles aggravent la marginalisation et ne permettent pas une récidive. Et favorisent la récidive, excusez-moi. La pandémie de Covid-19 nous a pourtant démontré que les États pouvaient agir rapidement pour libérer les enfants détenus et mettre en place des alternatives efficaces en collaborant avec le système de protection et les communautés. Et cela prouve donc que des solutions, elles existent à condition d'être soutenues par une volonté politique, de les financer, mais aussi de les coordonner. Et c'est d'ailleurs précisément pour soutenir ce changement de paradigme que la session aujourd'hui, elle va se concentrer sur deux approches clés d'une justice centrée sur l'enfant, qui sont la déjudiciarisation et la justice restaurative. La déjudiciarisation, en offrant une alternative aux procédures judiciaires classiques, elle vise à réduire le contact des enfants avec le système pénal et à éviter les effets néfastes et à privilégier des réponses qui soient à base communautaire, qui soient éducatives et qui soient multisectorielles. La justice restaurative, quant à elle, cherche à réparer les liens, réparer le dommage et engager des processus de réintégration et de guérison pour ces enfants, pour les victimes et pour les communautés. Elle accompagne donc l'enfant à comprendre, assumer et transformer les actes qu'il a commis, tout en renforçant sa réinsertion au niveau communautaire. Et ces approches, elles ne sont pas nouvelles en Afrique. Elles puisent dans des pratiques judiciaires traditionnelles et dans les valeurs des sociétés africaines de réconciliation, de cohésion sociale et de réintégration. Et des pays comme le Kenya, l'Ouganda, le Burkina Faso, l'Afrique du Sud, nous l'entendrons aujourd'hui, ont déjà intégré des programmes de déjudiciarisation et de justice restaurative avec des résultats très prometteurs en réduction de la récidive et de la détention. Donc aujourd'hui, cette session elle a pour ambition de mettre en lumière ces modèles, d'identifier les leviers de réussite et de dégager des enseignements concrets pour leur réplication et également leur mise à l'échelle à travers le continent. Honorable Hermine, vous êtes membre du comité africain d'experts sur les droits et le bien-être de l'enfant et depuis janvier 2019. Et vous exercez aussi la fonction de rapporteur spécial sur le mariage des enfants et les autres pratiques néfastes. Vous assurez aussi le suivi de la mise en œuvre des droits de l'enfant dans plusieurs pays. Originaire du Cameroun, vous êtes magistrate de profession, vous avez occupé d'importantes fonctions judiciaires et administratives. Et vous êtes également auteur de 4 ouvrages et plusieurs articles sur la parentalité, traite des personnes, l'évaluation de protocole de Maputo et également la procédure pénale. Alors, Honorable Kembo, dans le cadre de l'agenda 2040 pour les enfants d'Afrique, les États africains se sont engagés à garantir que les enfants bénéficient d'un système de justice pénale spécifique. Ma première question est la suivante. À l'horizon de 2040, selon vous, quelles devraient être les priorités et les stratégies pour accélérer cette mise en place d'un système de justice pénale spécifique afin de réduire durablement le recours à la détention? Et ma deuxième question, c'est de votre point de vue régional, quelles sont selon vous les pratiques, les innovations ou les dynamiques locales en matière de déjudiciarisation et de justice restaurative qui vous paraissent aujourd'hui les plus prometteuses pour une justice réintégrative et participative des enfants? Je vous remercie.
Merci Laura. Merci d'avoir associé le Comité africain d'experts sur les droits et le bien-être de l'enfant. Vous avez ici le salut des 10 autres experts qui, avec moi, certainement par ma voix, vous parleront et vous donneront, n'est-ce pas, le point de vue de l'institution qui est l'un des 3 organes de l'Union africaine en charge des droits de l'homme. Donc, je tiens à noter toutes les présences ici et à leur dire que leur présence est fortement appropriée. Sur la question que vous venez de me poser, je dois dire que on peut voir 3 approches globales. La première approche, c'est celle de l'appropriation, la localisation et la contextualisation des réponses. La localisation, la contextualisation permet de prendre en compte les pratiques locales, permet de les connecter au système de justice formel, permet de connecter ce système avec les pratiques dans lesquelles les populations se reconnaissent. Ça, c'est la première voie. La deuxième, c'est qu'on parle d'enfants. Et donc, lorsqu'on parle d'enfants, on devait travailler à une compréhension de la personne de l'enfant, de ses besoins, de ses difficultés, mais aussi de ses attentes. Et lorsque je dis cela, je veux dire que les systèmes de justice, notamment répressifs, doivent pouvoir intégrer les approches psychologiques, la personne de l'enfant, les approches sociologiques, l'enfant dans la société, mais également les approches anthropologiques. Parce qu'on ne pourra pas comprendre la relation entre l'enfant et le crime si l'on articule simplement la réponse en termes de réponse sécuritaire. Et cela m'amène à la troisième approche. C'est que dans nos États, les États doivent clarifier les options. Aujourd'hui, on remarque que plus le péril sécuritaire et plus il y a des contraintes sécuritaires, plus les réponses répressives sont utilisées en termes de durcissement de la répression, qu'il se traduit par des procédures qui restreignent les droits des individus, mais également en termes de peine. On note ce que je peux appeler un énervement de la répression. Les États doivent pouvoir décider pour les enfants entre ces approches-là et les approches en termes de réhabilitation et de justice restaurative. Parce que tant que ces clarifications ne sont pas faites au niveau politique, le système a de la difficulté à s'articuler. Et vous avez des professionnels qui ont de la difficulté à traduire ces options dans les actes. Parce que d'un coup, on leur demande d'avoir des réponses sécuritaires et d'un autre coup, on leur demande d'avoir des réponses qui protègent les enfants. Et entre les deux, l'infrastructure parfois ne suit pas. Ça, ce sont les trois approches qui, pour moi, permettront de traduire les aspirations, notamment dont vous avez parlé de l'agenda 2040, en ce qui concerne les enfants. Maintenant, vous me demandez aussi quelles sont sur le continent les approches que l'on a pu identifier qui vont dans ce sens. Les approches sont des approches qui sont essayées dans plusieurs pays. Je vais dire, une analyse de ces approches laisse penser que ce sont les approches qui connectent les systèmes de justice formels au système de justice informel. Parce que trop souvent, nos sociétés ont superposé les systèmes avec un système formel à côté, soit parfois des systèmes religieux ou des systèmes coutumiers dont l'articulation n'est parfois pas très claire pour les populations. Donc les systèmes qui connectent les systèmes de justice formelle et les systèmes de la communauté sont les systèmes qui permettent d'avoir les réponses les plus appropriées. Parce qu'il faut se dire, les systèmes doivent, dès l'entame, envisager la réintégration des enfants dans la communauté. Et c'est lorsque l'on travaille avec la communauté que l'on peut, dans la communauté, s'approprier les pratiques qui font que celles-ci répondent le plus et le mieux aux besoins des enfants. C'est ce que je pouvais dire sur la question. Merci.
Merci beaucoup. Merci beaucoup, Hermine, alors, pour cette intervention très riche et éclairante. Il vous a rappelé avec force que les politiques sécuritaires et de justice juvénile ne doivent jamais primer sur les droits de l'enfant et sur l'administration de la justice pour les enfants. Et qu'au contraire, c'est la protection de l'enfant et la sécurité qui sont deux objectifs indissociables et complémentaires pour briser les cercles de violence. Vous avez également mis en avant qu'il faut mettre au centre les priorités, les besoins et les attentes de l'enfant au centre des systèmes judiciaires avec une approche holistique, communautaire et multisectorielle et de renforcer cette articulation entre justice formelle et informelle qui est primordiale pour assurer que les demandes de l'enfant ne soient remontées et qu'on n'ait pas une justice qui soit top-down. Je vous remercie. J'ai maintenant le grand plaisir de vous donner la parole. Madame Patricia Pisjang, vous êtes féministe, écrivaine, avocate, militante, avec un parcours remarquable dans la promotion des droits de l'enfant. Patricia, vous êtes également alumnie du programme Young Africa Leaders Initiative et cofondatrice et directrice générale de Lawbot Africa, qui est une plateforme juridique utilisant l'intelligence artificielle pour améliorer l'accès à la justice en rendant l'information juridique plus accessible à toutes et tous. Patricia, so to start, pourriez-vous nous en dire un peu plus sur la déjudiciarisation et la justice restaurative en Ouganda et les initiatives que vous avez pu observer, comment elles fonctionnent concrètement, mais aussi comment ces initiatives rendent la justice plus participative et attentive aux voix des enfants. Et enfin, de manière plus globale, comment certaines actions ou mesures concrètes peuvent renforcer l'accès à la justice et la participation de l'enfant dans la manière dont la justice est administrée. Je vous remercie.
Thank you, Laura. I am very privileged to be on this panel and to discuss a topic that I'm very passionate about, not just as a young person within the justice system, but as someone that actively advocates for equality for all and for access to justice for all. Now, when we think justice, the go to perception is punishment. Who is wrong, who is right, and what sentence should be served. However, when we come down to looking at restorative justice, we tend to focus more on healing. We focus on rehabilitation and rebuilding the community and reintegration. And this is very important when we're dealing with children or when we're dealing with young persons, because we are looking at opportunity for change and we're looking at developmental aspects. And this is not an idea that is per se new to, let's say, Africans. I will speak from the perspective of someone that comes from a tribe that has, for hundreds of years, been practicing restorative justice. I come from the Luo people, and we have something called Mato Oput. Technically, we have the perpetrator come together with the victims and the families and the communities and the local leaders, and they look at who has been harmed, to what extent has damage been done, and how do we heal, how do we forgive, how is trust rebuilt, and how do we move forward as a community. And luckily, this is a system that is now being adopted by the formal justice system in Uganda. We have courts taking up this approach for particular cases that involve minors, and it's being championed by initiatives like Restorative Initiative Forum Uganda and Refugee Law Project. And they're doing all this to make sure that when children are in conflict and or contact with the law, the approach that is taken is not per se punitive, but we focus on how do we remold these individuals so that their voices are heard, so that they feel like they are not just problems to be solved, but they are part of the entire process, so that they continue to trust the justice system, but most importantly, so that they have a chance at being better citizens without exactly destroying their future in the process, or without, cutting them short and taking them through a process that would break them. And that has been our biggest focus. And today, when we look at these principles being reintegrated into the system, into the formal justice system, our biggest challenge that we're facing at the moment is the narrative that children are extensions of adults. So when we have them in the justice system and we are dealing with them, be it we're looking at them as victims or as perpetrators, we tend to dictate what should be done to them or what should be done for them. And this is particularly dangerous because it sways away from the definition of what justice is. Earlier on, we had a conversation on what maybe victims would deem fit as justice for them. And that can only be achieved when we particularly ask them what they want or what they need or how they would appreciate the situation being handled. And when it comes to restorative justice, that is a major focus because we speak to the victims and we ask them how they want to move forward or how they feel they can be healed. And then we also speak to the perpetrators and we look at how they can reconnect or compensate for the damage that has been done. And that is very powerful when it's done with children because they feel like they are participants in the justice system and not merely observers or subjects to the justice system. Now, when it comes to what can be done to make sure that this is taken up more and we have more impact coming in terms of the restorative justice, I think the focus should go to one, going to the young people or to the children instead of having them come to the system. We have already established that young people are not particularly trustful of the justice system as it is right now. However, we can go to the spaces that they are comfortable in or that they are safe in. And one of those spaces would be the digital space, which is exactly what platforms like Lobot Africa do. What we do is we recognize that all young people like using technology a lot. Young people like using TikTok. Young people like using WhatsApp. How do we incorporate legal information in a way that is accessible for them and consumable for them. So we then go ahead and build a chatbot, and then we put it in their WhatsApp, and then we share it with them. So as they're chatting with their friends, they also have access to this virtual assistant that they can contact in their local languages in English. And it breaks down complex legal jargons for them so that they are able to understand, but within their safe space. And then we have colleagues at Lakes Amica. All these initiatives are in Uganda, and they're creating 2D cartoons that explain duties and responsibilities of citizens, and what to do when you're in contact with the law, and what to do when you're in conflict with the law, and where to get assistance from, and concepts like Ubuntu, concepts like restorative justice, and what to do to be a better citizen. So you find that when we approach young people within their safe spaces, spaces that they are comfortable in, we have higher chances of having them trust the justice system, and we definitely have higher chances of achieving access to justice for all, especially children. And also we need to focus on training the professionals in the justice system, the former justice system, so that they take into account the context within which children or young people come into conflict or contact with the law. The justice system as it is right now often comes off intimidating for young people. When you look at a traditional court setting, the table is raised where the judge sits, and then there is a small dock where maybe the perpetrator or the witness will appear. That's a very intimidating setup, and young people may not per se be comfortable with going through that kind of process. However, when these trainings do take place, then we can have institutions or organizations go out of their way to accommodate these children, let's say within mediation circles, within schools. We create safe spaces where these children can then have all their issues sorted out. And in that way, we are rebuilding trust in the justice system, but we're also making sure that we build and mold these young people into better citizens and, achieve justice for all. Thank you.
Merci beaucoup, Patricia, pour ces éclairages et puis pour cette perspective très forte et inspirante. Vous l'avez dit, les systèmes de justice restauratifs ont cet avantage de placer au centre la participation de l'enfant, mais également de s'assurer que le développement de l'enfant est aussi va viser, se centrer vers la guérison, l'opportunité et la réconciliation. Par ailleurs, vous avez mis en avant que des initiatives à base communautaire comme Mato Oput, si je prononce bien, permettent d'inspirer justement la justice formelle, les systèmes de justice formelle. Et c'est important pour nous de nous rappeler que les solutions, comme vous l'avez dit tout à l'heure avec il, les solutions se trouvent le plus proche des personnes. Et donc, c'est à la base qu'il faut aller voir quelles sont les solutions efficaces qui sont créées, parce que les enfants et les jeunes n'attendent pas pour répondre à leurs besoins et leurs demandes de justice que le système de justice formelle vient près d'eux. Eux-mêmes, ils ont créé leurs propres acteurs, leurs propres manières, mécanismes de résolution des conflits. Et c'est important de s'en inspirer pour renforcer la confiance et nos systèmes judiciaires formels. Vous avez mis aussi en avant l'importance d'avoir des actions d'innovation qui sont conçues par et pour les jeunes à travers leurs canaux et d'avoir des procédures et des espaces adaptés aux enfants. Je vous remercie. Je souhaiterais à présent me tourner vers Madame la juge Theresia Mateka, qui nous a rejoints en ligne. C'est un grand plaisir pour moi de vous présenter Theresia. Theresia est juge à la division de la justice pour mineurs et présidente du Conseil national pour l'administration de la justice au Kenya. Sous son leadership, elle a mis en place un comité permanent sur l'administration de la justice pour enfants, un organe multisectoriel qui renforce la coordination entre les différents acteurs de la justice et de la protection. Au Kenya, le Children Act et la Diversion Guidelines prévoient un large éventail de mesures de déjudiciarisation qui peuvent être appliquées par les différents acteurs tout au long de la procédure judiciaire, et cela dès l'arrestation. Alors, Madame la juge Mateka, à la lumière de votre double expérience, à la fois sur le banc, mais aussi en tant qu'actrice de la politique judiciaire, pourriez-vous nous parler du cadre juridique et politique actuel sur la déjudiciarisation au Kenya, comment les programmes de déjudiciarisation ont évolué et la manière dont vous avez vu ces politiques et programmes transformer des résultats pour les enfants en conflit avec la loi? Pouvez-vous également nous parler un petit peu de la professionnalisation des acteurs et de cette approche multidisciplinaire que vous aviez favorisée? Est-ce que, selon vous, ces deux approches ont accéléré la mise en œuvre de la déjudiciarisation? Merci.
Thank you very much, Jacques. Thank you so much, and thank you for having me. I want to just begin by saying that the committee I chair is a NCAJ, a standing committee on the administration of and access to justice for children. We have a bigger council, the NCAJ itself, that is chaired by the Chief Justice. It is a high-level body that, where the Chief Justice and the other agencies at that level are represented. So that council works through committees, and the one I chair is on children. How did we get where we are today? I want to just start saying by when you ask about the legal framework, we begin with the international instruments, because in 2001 we passed our Children Act for the first time. That was to implement both the charter and the convention, but we did not put diversion in there. So for the next several years, we were using the Beijing rules to try and implement diversion. And you can imagine that it was not legislated. It was an effort to do something outside the actual law, but recognizing that children require more than just the normal procedures that are there in the criminal justice system. But later on, after we got our new constitution in 2010, we had an Article 53 there that speaks about detention being the last resort for any child that is in conflict with the law. And that gave birth to, after a long time, to the new act now, our new Children Act 2022, that has specific provisions on diversion. It's a long story. I may not be able to say all of it, but one of the things that came out clearly after the new constitution is that the judiciary was going through a transformation. And the Chief Justice then appointed a special task force that was to look into the status of children in the justice system. It came out clearly to us that about 90% of the children in rehabilitation schools for children in conflict with the law were children who did not have to be there. Something else could have been done. So it became necessary for us now to have that law in place. So how does diversion work now? We have put together policy. We had tried to put together some policies to guide us, but right now we just have the law itself, and we are trying to implement it. We are the place where you say, how do we implement diversion? What we have in place, we have the court users committees, the children court users committees. These are where the magistrate, the police, the children officers, probation officers sit to be able to discuss this particular issue. So on the how to implement diversion, then it calls upon us to work together as a team, because the realization is that one particular person cannot implement diversion. The child requires every agency along the way to be able to do their role. And what are these roles? The magistrate has their role, the police officer has their role. For example, we have something in the law that says that the moment a child is arrested, the police officer must inform a children officer who will prepare a report that is presented before the magistrate, so that at that point, at the point where the child is entering the justice system, all these people, the police, the probation, the prosecutor, the children officer, the victim, and the complainant, and the offender can sit in one room and actually discuss and see, is this a case that should go beyond this space? And the court is able to decide at that moment whether that is a case that should be taken for trial or it's a case that should go to diversion. But the thing that we still have a challenge with is what programs to put in place. Where do we divert this child to? Because as you were asking whether diversion has become the first point of call, we are still not yet there because of the challenges that I've heard some of the people talk about, that we need the community itself to be able to provide the places where when a child requires that rehabilitation within the community, that there's an intervention, there's a program that is available. So as the Kenya Child Justice System, we are working on that. And in fact, we have a very good example of one of the committees, the court users committees that has been working on this. They've decided to take up this particular law and see how it works within their jurisdiction. It is called the Tononoka Children's Court and the Tononoka Child Users Committee, Court Users Committee. They partnered with the University of Nairobi, the Mombasa branch, and they're actually carrying out, not only implementing diversion within their jurisdiction, but also carrying out research at the same time, so that we create an evidence-based regime of how we are going to make sure that diversion works for children. So a lot about that. But we have the multi-agency system that is what is helping us to try and implement diversion. Because the recognition is that the child will come from the community, and if they enter the justice system, they'll pass through the justice system and still go back to that community. But in the meantime, then we must be able to uphold the dignity of this child, because we are aware that the child justice system, rather the criminal justice system that we have, was not made for children. So having diversion in the law has actually launched the largest or the biggest paradigm shift for us in the child justice system, in that it tells us from the word go that the moment a child is in conflict with the law, that child must be considered differently from an adult who gets into conflict with the law. What have we come up with? We've come up with a file, I'll just call it that is called the Protection and Care File. The magistrate, the police officer, or the prosecutor or the court can direct that this file be opened, but ideally it ought to be opened at the police station, so that that report I mentioned that talks about the welfare of this child, where the child has come from, what is the condition at home, what is going on with the family, actually gets to the attention of the court, so that even as the court is dealing with the issue of the offense the child has committed, there is an actual consideration of the welfare of this child. And that is what will directly influence the kind of diversion program that comes into play. So that at the end of the day, you are looking at how best do we handle the situation that made this child commit this offense, and what happens when we finish with this child? Where do we take this child? How will we ensure that they don't commit the same offense? So this diversion and the other, because it's not the only non-custodial measure that we have, but there are others that are available, actually are very much influenced by that investigation that is carried out. And the court has, is obligated to look at those reports and to see how to implement that. But that can only work, as I said earlier, when everybody is able to know their role along the way. And that is how the court users committee, that's how it comes in, because it is within that committee that everybody gets to be trained on these particular issues, like the committee I mentioned to you, Tononoka, where they come together and get someone to take them through. And when I say all of them, it means from the police, from the probation, from the prosecutor, the magistrate, all the other agencies. They sit in the same room and they get this training together so that everybody understands their role and what they need to do. At the end of the day, that the child is at the center, and all everybody else needs to do is to do their role along the way. So basically, for us, that's how it works.
Thank you, Theresia.
within the
Thank you very
Kenyan
much.
system. Thank you. Yes.
Merci beaucoup. Merci, Theresia, pour ce partage d'expérience très précieux. Et je pense que vous avez mis le doigt sur deux approches fondamentales qui sont la professionnalisation des acteurs. Mais par professionnalisation, j'entends aussi la compréhension du rôle de chacun et de tous les acteurs à la fois du système judiciaire comme les acteurs du système de protection de l'enfance, qui intervient à quel moment dans la chaîne pénale, mais également cet aspect, enfin, cette approche multisectorielle. L'importance d'être assis ensemble à la table pour comprendre la situation de l'enfant et de décider ensemble de quelle est la mesure qui va lui permettre sa réintégration, de retrouver la place d'enfant et de devenir à nouveau un acteur de transformation de son futur et de ses opportunités. Merci, c'était très éclairant. Je souhaite maintenant donner la parole à Madame Christina Namdo, première commissaire pour enfants et spécialiste des droits de l'enfant au sein de la Commission nationale de planification d'Afrique du Sud. Au cours des 4 dernières années, Christina a conduit une initiative pionnière de participation des enfants, visant à intégrer la voix et les expériences des enfants dans la révision du plan national de développement. Et avant cela, elle a dirigé pendant plusieurs années RAPCAN, une organisation sud-africaine de défense des droits de l'enfant qui a permis d'institutionnaliser des pratiques de prévention des violences faites aux enfants et de porter des réformes constitutionnelles majeures protégeant leurs droits. Donc, Christina, pour commencer, l'enfant est au cœur du système de justice sud-africain depuis l'adoption de Child Justice Act, qui fait de la déjudiciarisation et de la justice restaurative les piliers de la justice pour mineurs, y compris pour les infractions graves. Alors, pourriez-vous nous expliquer brièvement le cadre légal national, comment cette déjudiciarisation et les approches de justice restaurative qui sont prévues, la médiation, les conférences de groupe familiales, sont mises en œuvre concrètement aujourd'hui et quels sont les défis qui demeurent, qui empêchent une application qui puisse s'appliquer à l'ensemble des cas? Et puis, vous avez toujours défendu avec force la participation active des enfants et des jeunes dans l'élaboration des politiques et des systèmes. Alors, dans le contexte de déjudiciarisation et de justice restaurative, comment pourriez-vous garantir que les enfants ne soient pas seulement des participants dans des cas individuels, mais aussi de véritables co-créateurs, influenceurs et développeurs de ces programmes? Je vous remercie.
Thank you very much for the warm welcome, and to all the participants present and online. Thank you for the opportunity to share our experiences in South Africa. I think there's a tendency to sometimes over-romanticize the experiences of South Africa because we already have Child Justice Act since 2008, and everything theoretical that should be there is there. But whether it happens on the ground is a completely different story. And you know, I've communicated with implementers and also some strategic litigators around this issue, asking them whether we have actually reached those ideals we wanted to achieve. And they have told me there's a mixed bag. You know, we should be very proud of the fact that we do have the legal framework that protects and promotes the participation rights of children in the justice system in their own cases, framed from the perspective of Ubuntu, which protects the dignity of the child, the accountability, but also the reconciliation and community involvement in their process in the justice system. And we're moving away from the orientation from punishment, at least in the legal framework. And diversion is the preferred option to keep a child out of the formal criminal justice system, with a preliminary inquiry and assessment done by social service professionals who then understand the context of the crime. As Honorable Teresi has also said, this is very important to understand the context in which the crime was committed. For example, I can mention in South Africa that we have a very complicated set of factors that lead to children becoming offenders, but also we must hold in our minds that they are also at the same time victims, because they may be used by adults to commit crime. So, for example, in the area where I live, where gang activity is rife, children are even recruited in gangs to be hitmen, and so face murder charges in courts. And so very serious, very serious crimes are leveled, are committed by children, but they are basically victims of adults manipulating them as well. So whether we see the restorative justice emphasis and the victim offender dialogue, I remember when I visited some prisons in the oversight capacity that I had, that, for example, the pastor or the priest in the center would hold this role to bring together the parties of the families and also the child or the young person who offended. And he mentioned to me that the young people really take this very seriously. They take the power that he holds to determine their future very seriously, and so they try to cooperate with these processes that will enable them to reconcile themselves with what they have done, but also apologize to the families that they have, they have robbed them of perhaps their loved ones. And so we see processes that uphold the best interests of the child and the participation rights of the child. But also these cases are treated contextually and individually, because our age of criminal capacity being 12, in adolescence, we have to look at the development of the child, but also some of the factors that influence maladaptive behaviors in a child. So these contextual factors are very important. We say that we orientate from Ubuntu, I am because we are. But in South Africa, we really face a crisis of humanity in that households, communities are falling apart. There's a lot of dysfunction in those institutions, which make children even more vulnerable to be used by adults who can manipulate them into criminal behavior. And so we really need to deal with empathy in around child offenders, as we need to understand the context from which they are caught in these circumstances. And so we may have we have community-based counseling services and diversion programs in our civil society sector, and sometimes within even our secure care centers. I have seen, when I visited some of our secure care centers, some of the programs that they have on offer there. Practically, the implementers of the programs inside the care center tell us that sometimes this is the first time that a child can access continuous education, who can be met at the level at which they are. Sometimes children have intellectual disabilities which make them more vulnerable to criminal activities, falling out of the school system. In the system of care, they are moved through certain creative programs, educational programs, and so we see that for the first time, once they are committed to care, not in their communities where they oriented. So we need to look further into what drives, children. So there's uneven application, of course, because the resource base will be different everywhere. And we need to do more to capacitate the key personnel within the systems to not only have the skills to implement restorative justice, but to also have made that paradigm shift that many have spoken about, from punishment to support of and rehabilitation of the child in the time frame that it is most likely that they will be able to transform their lives. Child human rights defenders who walk alongside me in my work have spoken very eloquently about being given a seat at the table, being able to talk to the decision makers, being able to influence not only policies, but also laws and practice around not only the justice system, but for examples, what creates a violent society and why our societies are falling apart. And so I think we all need to make this shift where children become active citizens and start to shape policy, law, and practice in our countries. Thank you.
Merci beaucoup, Christina, pour votre témoignage aussi très honnête sur le gap, le fossé qui continue d'exister entre la théorie du cadre juridique, mais aussi la pratique en Afrique du Sud. L'importance aussi que vous avez rappelé que les enfants en conflit avec la loi sont très souvent issus de situations de vulnérabilité, de marginalisation, et qui sont eux-mêmes très souvent victimes de violences et de violations de leurs droits, et que la réponse, elle ne peut pas être prise en étant dissociée de leur situation, du contexte, mais aussi des moteurs systémiques de violence, si nous voulons briser le cycle de violence. Je vous remercie. Avant de passer à la suite de nos échanges, nous souhaitons entendre une voix très spéciale, celle d'une enfant, celle de Imi, qui est une défenseure des droits de l'enfant en Afrique du Sud. Imi, dont nous allons découvrir le message vidéo, nous partage un regard frais, sincère, sur le monde qu'elle souhaite pour les enfants. Alors, même si ces mots ne partent pas directement sur la justice pour enfants, ils nous rappellent avec force que la participation et l'expression des enfants sont au corps d'une société plus juste, plus humaine, plus inclusive. Et je vous souhaite d'écouter son message avec cette idée en tête. Quelle place laissons-nous réellement aux voix des enfants dans nos systèmes, nos institutions et nos décisions?
Greetings everyone, my name is Imazuri Janki and I'm a child human rights defender. I became a child human rights defender in 2022 where I had met Christina Nomdu, who came to my after-school art class program where she taught us about the 3 Ps and she did a children's rights workshop. We learned about the children's rights of the United Nations Convention on the Rights of Children, and Christina, who was the first Western Cape Commissioner for Children, had helped us to understand the topics, and she chose, and the children that were interested had went with her to go work with her in the Commissioner office. I learned about children's rights during our Wednesday WhatsApp sessions from 5 p.m. to 7 p.m. This is where we would discuss and evaluate children's rights, and we had a chart that we looked over about all the children's rights that there was. Christina Nomdu and the CGMs would work alongside the government by having documents that were sent to them and altering it to make it child friendly so that the children were able to understand any difficult terms that they wouldn't know. I have advocated for children's rights health services and did lobbying processes where we went to 2 different hospitals and a day clinic. There we were informed about their budget of the equipment and how they use their budget accordingly so that they don't run out of supplies. And they experience budget cuts, and if there's a budget cut the previous year, they won't have enough money to be able to support them the following year in any supplies and any equipment for the hospitals. The Commissioner, Christina, would make sure that we are comfortable discussing topics that are sensitive, and she would not let us go into children's centers where there was children that would hurt or anything, and only adults would be allowed to go in as the topics would be too sensitive for us to experience. We recently launched the Child-Centered Governance Academy, where the old CGMs some of the old CGMs came along with Tina to work with them. Last week, we had a workshop at the Academy where we were doing the topic violence against women and children, and we made posters about what we know of the violence that is experienced to children and women in South Africa. Through this Academy, I hope to continue to expand my education about children's rights and be the voice for any children that don't know how to speak up, and also teach them what I've learned through the Commissioner for Children. Thank you.
Je pense qu'on peut l'applaudir et je voudrais encore remercier Christina pour tout le travail qu'elle fait avec les enfants pour justement leur permettre d'avoir une voix, notamment aujourd'hui parmi nous. Je voudrais directement passer à l'ouverture des questions et réponses avec le public parce que we run a bit of time. Donc, merci beaucoup à vous toutes, nos panélistes, pour ces interventions aussi riches qu'inspirantes. Je crois qu'on pourrait continuer à vous écouter encore pendant longtemps, mais c'est maintenant à vous, le public, de prendre la parole. Alors, nous allons ouvrir la discussion pour une quinzaine de minutes. Je vous invite à vous présenter brièvement et afin de poser la question et d'identifier la personne également à qui vous adressez votre question. Merci.
Thank you. Good afternoon. I am Abbas Luyombo from Uganda, young justice leader with Pathfinders. Two questions. One will be for Patricia. You explained the idea of how we could use internet and social media to ensure children can access and understand how possibly they ought to be treated in the justice system and what rights belong to them. But I'm just imagining whether you look at the consideration as well in light of the state of Africa and the rate of internet penetration and access, but also how much protection you accord to the children in situations where in using these spaces, either there is this high rate of misinformation or disinformation, or in the alternative, the data which they share that belongs to them as children. How do you safeguard all those different aspects, but majorly in light of the fact that if mature persons above 18 years accessing internet or even using it is a problem across the continent, then how do you tap into the young people who appear actually so far a bit from these digital spaces? Then the other one is a question to, I think it was panelist number one. So it's when you look at the African Charter on Human and People's Rights, I think largely the jurisprudence that has come out around Article 19 to 21 of the Charter and how it looks at who or what is the definition of people or a people. So I imagine, how do you see the crisis of centering child-centered justice and people-centered justice, whereby in certain situations, a people might refer to a community, and in most cases, our communities, especially in Africa, customary systems have largely lowered the status of children to the extent that they ought to be seen but not be heard speaking. So how do you deal with the balance of you want to ensure justice is people-centered, and in this aspect, you're not looking at the people as the individual, but the people as a community, that you respect what they call justice, but you also uplift child-centered justice, which justice, despite its importance, in certain circumstances, it clashes with some of the customary practices that we have in our communities, which practices are very key in dealing with justice and supporting the various justice mechanisms. Then finally, it's a general one that with all these diversion practices that have been embraced, especially in countries in Africa, Kenya, Uganda, South Africa, how do we think states must work around child justice financing when even on the larger scale of justice financing, you still have deficits or it's not yet a priority? But then many of the mechanisms that are suggested to center justice around children and to ensure they are protected from the harsh criminal justice system, they require financing, but yet our mechanisms are currently still very low around justice financing across the continent and within the various jurisdictions independently. Thank you.
Est-ce qu'il y a d'autres questions dans la salle?
Okay.
Thank you.
Thank you. So I'm Joke from Center for Legal Support and Inmate Rehabilitation in Nigeria. And I'm not asking a question. I'm just going to make a comment from some of the things that has been discussed by the panelists here. And I would really want to say that, of course, just like what we've been, the conversation that has been in the room, to start having push conversations that are much more centered on the children. And I'm saying this from the experience that we've had in the course of the work. Let me say last year, we discovered that a lot of the children who are incarcerated do not actually have access to education compared to their counterparts on the outside. Particularly, and I would rather not refer to the state, I mean, with regards to my country, we discovered that this is actually a state that is assumed to be at the forefront of the justice conversation. And we discovered that children in conflict with the law only have access to education up to grade 5. So grade 5 is called primary 5 at our hand. All things being equal, children around that age should be maybe like 9, 10 years thereabouts. But these are centers that are set, they are set up particularly to cater for children between the age of 9 and 18 years. So it simply means that every child who is above 10 years, who is 17 years, comes into the center and only has access to grade 5. And as far as I'm concerned, that is destroying the lives of the children even before they become adults. For an offense, they do not even know the gravity of what they've done. And another thing that made us, really want to pay attention to this is because even the Child Rights Act, which of course it's been seen in Nigeria, provided specifically that every young child should have access to education up onto JSS 3. So JSS 3 should be like around maybe like grade 8 or 9 thereabouts. So you're denying those children access to education, you're denying them of their rights. And this is where I feel like the people-centered justice when it comes to children should come to the foreplay, because we already have the backing of the law, the provisions of the law are there. For us as an organization, we try to make to engage stakeholders to say this is what we have observed, and we saw that there was very minimal attitude with regards to the political will in putting these things right. We started up the juvenile education program where we teach them every day, but of course we know it's not sustainable, because we're talking about just one center. The country has over 200 million people. What happens to the children across the other parts? And that has been a thought for us to say, how can we start amplifying these problems that we've seen? How can we start saying, there's this conversation about we're trying to ensure that children do not stay long in the justice system, but you have children who have stayed 5 years. What happens to them? They're already staying long. Their mates are already making progress in terms of education. So we can't just say, okay, we don't want them to stay long, because we heard that statement when we're engaging stakeholders to say, we're trying to take them off the system. While that is good, we also need to think about children that will stay long in the system, how they can be protected, how they can be rehabilitated, and they can still compete, with the outside world. And I would also want to say that I'm taking away what the Honorable Judge said with regards to what's being practiced in Kenya. as regards protection and case file, where you're looking at the welfare of the child. What has been like, what's life like before this child came in conflict with the law? What's the status of the parents? Are the parents available? Are they there? And I think when we start having that conversation, we will definitely be able to start addressing issues that affects the children. Like, for instance, in one of the centers where we work, we discovered that quite a very large numbers of the boys are actually being charged for defilement. While, we can get very touchy when it comes to sexual offenses, but the question we should be asking is, why is there an increase in that number? Why is there an increase beyond we want to punish sexual offenders? They need to be kept away. But why is there an increase? Why is it that young boys, young children are now being charged for defilement? And that's where the people-centered justice should come forward, where we are moving beyond just punishing them, leaving them in the correctional center, to addressing the problem, the root cause of the problem, and seeing children who are in conflict with the law come out of that system to still be able to contribute productively to the society and to the entire continent. Thank you.
Merci. Peut-être une dernière question? Oui, je t'en prie.
Thank you very much to you all. My name is Aliu Kamara from the Gambia. I just need to ask a few questions regarding the justice system for children. And my questions goes to all the panelists there. Number one, what are the most significant challenge facing children in the justice system, and how can we address them? The second question is, how can we ensure that the justice system prioritizes the best interests of children for children, and then treat them with dignity and respect? And the third question is, what strategy can we implement to prevent children from entering the justice system in the first place? And my final question is, how can we ensure that children receive adequate counseling, education, and vocational training while in detention and after release? Thank you.
Merci. Je pense qu'on va d'abord peut-être prendre les questions qui ont été données et puis on verra si on a l'occasion de faire un deuxième round. Je vous remercie. Désolée. Oui. Très bien. Peut-être du coup la première question, Patricia de Abbas. Would you like to answer?
Thank you very much. I will respond to the question that was raised by Abbas. When it comes to protecting children, especially when we are looking at introducing solutions that are tech-based, we have gone an extra step to ensure that stringent regulations are put in place, not just on paper, but in practice. A case in point was when we were working on the virtual assistant Robot Africa. We were very particular, one, to ensure that the information we use for training these chatbots were from authorized sources and they were verified. And we also had to make sure that we closed the back end and prevented the retaining of data. If you look at how platforms like ChatGPT operate, they retain the data of the users. So if you go on there and then you give it false information, it will retain that. And chances are next time it's going to give that kind of information to another person. Now, recognizing that we're dealing with children that might be gullible and are vulnerable to some of these vices, we went ahead and made sure that we closed the back end. And this is information or practices that we have shared with other entities that are also building some of these solutions. We make sure that we protect the kind of information that we are using to train these chatbots, we're using to design these campaign strategies and communication tools that we are going to use when we're working with children. And this is just more than just about disinformation and misinformation. We also make sure that the regulations go ahead to address things like function creep, so that if the chatbot is meant to only give information on legal aid, that's all it's going to do. We do not want to leave it to chance, so that maybe bad people who are out there, or people that have ill intentions, use that opportunity or that loophole to have access to children and potentially expose them to abuse. And then when it comes to the aspect of addressing the digital divide, which is very prevalent in Africa, we recognize that from a resource point of view, we may not be able to access every child and, give them gadgets and provide them with network and internet access. However, we try to use a method that causes a ripple effect. So what we do is we go into these communities and train the local leaders that have access to children, and then we train teachers, and then we train the leaders that children have most access to, and then we give them some of these softwares, access to these softwares, so that when they come across children that are in conflict or contact with the law, they can then present these solutions to them. So then we are using one person or one or two or three leaders in the community to have access to multiple children. And in that way, we sort of address the challenge of the digital divide amongst children, but also do it in a way that is within our means. And then the last question that was asked by the gentleman on what challenges we face when it comes to children and the justice system. From my experience as a young justice leader, the biggest challenge that we have faced, one is exclusion, treating children as subjects in the justice system and not active participants. And that results into us giving them a blanket approach, which is how most children end up being incarcerated, or which is why when we have, let's say, solutions for children, we do not consider children that are also extremely vulnerable, like children of incarcerated adults that are also victims and deserve justice, but we don't look at that. Or let's say refugee children, or internally displaced persons, or children that are able differently, or children from disadvantaged points of disadvantaged backgrounds when it comes to the economic aspect. These children face extra challenges, or these children are extremely exposed to injustices. But when we do not include them in our justice approaches and solutions, we just give blanket solutions, which does not address the situation. So those are some of the challenges. Thank you.
Merci beaucoup. Je vais à présent passer la parole à l'honorable Kembo concernant la question sur l'éducation.
Okay, let me answer in English as the question was being asked in English. On the issue of balancing child-centered and people-centered, with the presumption that the people-centered would frustrate the interests of the individual child. I think here we need to bring together contextualization on the one hand, but on the other hand, adaptation. Community justice system need also to be adapted, and one of the means to adapt it is to understand understand the who is the child, because the premises on which the rules were brought up in the societies didn't take into consideration the individual perspective of the children. So nowadays, you have many streams of knowledge which can help us have light on that. So this can also be done by training the people who the people who on the ground providing justice to the children, even in the community. So first, to be understanding what is the children, and that can help transform also our community justice system. Now, the second issue was the issue of financing. How do we claim that? How will justice for children be financed, whereas even the global justice system is lacking the finance? Here we also need to see justice system as a part of the global system. Justice with children is part of the global system, not only involving the justice sector, but also involving other sectors. So hereby the need to connecting the dots between the various sectors. We need to connect the dot. When I have a child and Justice Mateka, she clearly posed a problem when we want to divert a child, where do we divert the child to? We need to have a mapping of the different stakeholders on which stakeholders is providing which services. And therefore, we bring the justice on board and earmarking the relevant sector which needs. So we do not need just to have the financing goes to specifically the justice sector, but see the financing of the sector as a global issue of the global system. Now on education in prison, on how to articulate it. I think also on that, there needs to be the global articulation of the education, because you said the principle is that a child accesses, have the right to access education up till a certain age. But in the centers that have been, where the child is being received, his access to education is stopped at a certain level. We also need to see that that access to education for children incarcerated is not distance from the normal education system, and that could be taken on board by the ministries of education, embedding that and incorporating that education in the system, seeing into it that there are some children who cannot, by the mere fact that they're incarcerated, they cannot access the school in the same way like the other children, but still embedding them in the system. And that needs the collaboration between the Ministry of Justice and the Ministry of Education. So therefore, there is also a dot which needs to be connected. And then on how to bring the principles, how to trickle down the global principle. You said the children have the right to education. We need to be clear that all this global principle, for it to trickle down, for it to be a reality in the life of a specific children, there is a machinery. There is an institutional machinery that has to be moved. And how is that moved? It is moved through procedures. So we need to clearly take the principle and lay down the procedures and also identify the various responsibilities of the various stakeholders for that principle to trickle down in the realities of the children. And on the challenges, what is the most significant challenge? I think the most significant challenge in my opinion is the comprehension of the children. Because if we do not have an understanding on how children works things, basically we are going wayward, and we are giving solution that does not meet the needs of the children. So for me, that's the big challenge in this issue, beyond the challenges of resources. But the first point of call should be to better understand what is the child. Thank you.
Thank you very much. Pour la dernière question, je ne sais pas si juge Theresia, vous voudriez répondre peut-être sur comment empêcher que l'enfant soit en relation, enfin, soit en contact avec le système de justice in first place.
Thank you very much, Jacques. I just want to agree with Hermine on everything she has said about what must be done. For us, we have to always remember that the first question is, who is a child? And I always go back to the preamble to the charter. It lays down to us the unique place the African child holds. That, for me, gives us, it just kind of gives you the guidance. What are we looking at? Every child is unique in their own way, even if they're in the same situation as another child. So the thing that, and I'll give you maybe just the examples from home here, that, for example, one of the things that we do every year from 2016 is we have the Child Justice Month. During this month in November, it started as a time to clear backlog of children cases because it was found it started as a clearance of backlog for cases in the judiciary. And then as a task force, then we asked ourselves, but who is going to clear? Why is there nobody talking about clearing backlog of cases for children? Yet it has been found that there are many children in custody awaiting the hearing of their cases. And we made a request to the Chief Justice and he said, okay, go ahead and organize a child service month. So we began by saying it does not matter. Every court that has a children's matter, you must put it down and try and deal with it within a certain period of time. We saw a huge number of backlog of cases because everybody stopped what they were doing and concentrated on the children cases, the prosecutors, the magistrates, the children officers, the probation officers. We had volunteers coming to help with certain things. What did that do? It helps us to see how children enter and how they stay and how we contribute to their staying and their lack of education and all the violations that you can imagine. So from hence, every year, we are able to look at, sit down and plan. We are doing the same this year. In this November, we'll have a service month, but it has morphed into another thing. It is the month when we all talk about rights of children, access to justice for children, in whichever way, wherever you are. This year and last year, counselors have been how do I say, volunteering their services to counsel families and children so that, because we believe and we know that any child who is in conflict with the law is a symptom. The way you can have a headache and maybe you have malaria or something else is a symptom there's something wrong. So we have to find, if we have this child here, how do we deal with this symptom and go deal with the problem? So we've had counselors coming in and they identify some of these problems and the court is able to be assisted in the justice system to address them. Another thing that we have come up with is a clubs of, we call them Watoto wa Wakili clubs. Sorry, Wakili wa Watoto clubs. These are clubs made of students who are lawyers, student lawyers in the university who come up and form a club that just talks about rights for children. We realize that there's a certain age difference that we have. If that young student goes to a school, to an institution, to that rehabilitation center and speaks to those children, they have a certain connection. So we have that, and they've been doing that for the last 3 years. And now we have people who go out there and bring us that information. This last Saturday, they went to 3 institutions. And you see, when you get to know where the problem is, you can prevent it. Because when the children tell you how the problem begins, then you can prevent it. And they have told me, Judge, we have to have a meeting, a physical meeting with you to tell you the things that the children told us. So that means we will have information right from the children who have been incarcerated, right from the children who are at risk of incarceration, to be able to look at how do we prevent that entry. But as a justice system, we have something called through care guidelines. I think I mentioned, we realize that the child comes from the community, will pass through the system and go back. The community is the place we must meet. We must meet there. And I agree with Madam from Cape, Western Cape, that we have a lot of good things in writing. We are trying on our part, in the smallest corner that we find ourselves, to see that we implement what is written in the law. So that when we do that, then maybe out of there we'll get another person to help us, so that I can finish. Now, on financing, I had to say something. When we passed the new law, we realized, because the last law was not financed, we costed the bill. Every agency looked at the bill and said, this is the part I am going to implement. And therefore, in my budget, I want government to increase this by this amount so that I can meet the needs of children. Of course, children don't pay taxes. They don't sit in parliament to argue their case. And therefore, part of those things were not dealt with. So we have a nice bill, but I can assure you, for as long as our countries do not put money into the justice sector for children, we will never stop having these problems. The children will continue getting into conflict with the law. They will come in, they'll not get education, their rights will be violated. They'll come out and be very angry with us. And we see that all the time. And finally, someone talked about how culture how do we deal with customs and culture that actually lowers the place of children in society and sometimes contributes to the violation of their rights? How we do it, or how we've been trying to do it as my committee, is to meet every community in their space, so that we will go there and sit down and listen, because you cannot say, I'm going to arrest this father because he has married off his daughter to this other person and the daughter is a child. You have to find out what is going on and address the root problem. We have a certain community we went to, and they do they have the girl, maybe something they call engagement when they are 5 years old, and we went there and they told us the bandits have taken the cattle, the rest have died in the famine. This little girl is the one who can bring cattle to my home. What are you telling me, that I cannot be able to bury her?
Thank
So you
you,
have to
Teresa.
deal with
We'll
that
need to
problem.
wrap up
So,
because
so thank
thank
you very
you.
much for those. But those are some of the things I can
Thank you.
contribute to. Thank you, Jack.
Thank you, everyone, for your very relevant questions and also for les interventions très riches de nos intervenantes. Je vous remercie pour votre écoute attentive également dans le public. Nos échanges aujourd'hui ont démontré à quel point la déjudiciarisation, mais aussi la justice restaurative sont bien plus que des alternatives au système judiciaire classique. Ce sont des leviers essentiels pour réduire la détention des enfants et bâtir des systèmes de justice véritablement centrés, mais à condition d'impliquer l'ensemble des secteurs, les communautés, d'assurer la professionnalisation des acteurs, la participation des enfants, le financement et encore bien d'autres leviers dont nous avons besoin, et de game changers pour s'assurer que ces justices centrées soient une réalité pour les enfants sur le continent demain. Alors avant de conclure, je vous propose juste de dire un mot, chacune de nos intervenantes, sur quels sont pour vous, les game changers, le message clé que vous voulez passer pour que demain nous puissions bâtir encore davantage des systèmes de justice centrés sur l'enfant. Merci. Un mot.
Un mot. Le message clé que je voudrais faire passer, c'est nous donner les chiffres. C'est que d'ici 2050, l'Afrique aura 1 milliard d'enfants, c'est-à-dire 1 milliard de personnes de moins de 18 ans, ce qui constituera les 40% de la population d'enfants dans le monde. C'est-à-dire que si nous voulons, d'ici 25 ans, en faire une force de transformation, c'est aujourd'hui qu'il faut agir. Si nous voulons aussi transformer l'énergie de ces enfants en une bombe qui sûrement va nous exploser à la face, c'est aujourd'hui qu'il faut décider. Donc, agir et réussir ensemble, ou ne pas agir et périr, je pense que nous avons à décider. Et l'action, c'est aujourd'hui. Merci.
Thank you very much. I would just like to conclude that when we're done with this meeting, which has been very nice, let us go back on the ground and do the actual work. If we want to have a generation of better citizens that love wherever they're coming from and are working to having a better global community, let us go beyond the best practices that we're sharing here, beyond the laws that we are writing, and go down and make sure that implementation is actually done, and that implementation is monitored, and we revisit it, and we make sure that we keep on reshaping it to suit the context of that time. Thank you.
Thank you. Judge Mateka, would you like to say one word? Je pense que nous avons perdu Theresia, mais peut-être Christina, si vous désirez dire un dernier mot pour conclure. Je vous remercie.
Thank you. I think my phrase of the day would be, change begins with me. We are the adults that construct these societies that are unfair towards children. And so we must look deeply into cultural taboos, into gender and class, these big things that affect children that creates crime and violence, and also the hierarchies of power. It is us as adults who need to reframe our position to meet children where they are. Thank you.
Thank you very much for being with us. And we're going now to give the floor to the next session. Thank you. Thank you, Christina. Thank you, Teresa, for being with us online. Thank you.
Thank you for that session on justice for children, which was very insightful. I mentioned in the morning we were excited to hear from a child and also from young justice leaders and judges as well. So this was a real intergenerational dialogue of various partners, and we were very excited about that. In the interest of time, we're going to move into our last, but certainly not least session, one where we're looking at diverse pathways to justice. This is a matter and an issue that's been spoken about all day in different ways, about how we make sure that we harness some of our cultural and traditional practices on the continent, how we look at the fact that most of us are not going to traditional or rather to formal legal court systems, and how we can embrace the diversity and plurality of pathways to justice on the continent. So I'll ask the speakers for the next session to please come up and get situated so that we can start that session. Thank you.
Good morning, everyone. Good afternoon. You're right. Good afternoon. This is a wonderful room, of course. I'll do it later. This is a wonderful room, of course, but at the same time, I feel quite far away from everyone. I hope you can see me on the screen somewhere. Okay, let me just stand up for the first part, just to get your energy going. So, okay, we are the last session, but we still have a lot of business to attend to. We have a resolution to craft and some decisions to make. But Themba gave us a good start when he was talking about diverse pathways of justice, which will be the theme of today's session. Let me give you a quick example. So imagine you are, you have your house, you like your house very much, and your neighbor starts growing a mango tree. Wonderful, no? A mango tree. And then with the years, the mangoes of your neighbor starts falling on your garden, the garden you've been neatly curating. No big deal at first. You take some of the mangoes, not a problem. And then in the peak season, one after the other, sometimes hitting your car, sometimes destroying the way you've been taking care of your garden, of your driveway, and so on. I want to ask here, who here would take this matter to court? Raise your hand. Who here would like to discuss with your neighbor? Okay, good. Who here would like to maybe call the priest of the church to try and mediate, since your neighbor doesn't want to speak to you? Anyone would like to speak to the priest? Who here would like to call the mayor of the city for this case? Anyone? Okay, so I think we have agreed that we're going to resolve this matter with a conversation with the neighbor, right? Okay, let me give it a try. Hello? The neighbor doesn't want to speak to you. The neighbor does not want to speak to you. Okay, anyone here will take this matter to court? Raise your hand. Still not. The mangoes keep falling. Your car is full of dents. It's over. No court yet. Okay, will you call the priest now? Someone maybe. Okay, I have one person calling the priest, two. Okay. There's someone at the end of your street that is well respected in the community. He facilitates a lot of the discussions between the neighbors. Would you go for this guy? Okay, then. So, the court, maybe not for this case. The priest, probably not. You would probably go for the mediator, right? It doesn't matter whichever is the route you take. The one thing you want is justice, right? You want your driveway clean. You want your car without the problems. You want your neighbor to stick to his own corner, correct? So today's conversation is not about mangoes. It's not about driveways or houses. Today we're going to talk about diverse pathways for justice. Sometimes we take different routes, but we want to get to the same place. And the place we want to get is people-centered justice. It's justice that addresses the needs of the people. And my distinct panel here has excellent examples of how in their communities, in their countries, in their jurisdictions, they have been applying diverse pathways of justice, with or without traditional methods, with or without the use of institutions and frameworks and so on, but in different ways that they have been addressing justice in their own work. Okay? I'm going to have to sit, so you're going to have to rely on the screen for the next bit. Okay. To get us started, we are here with Dr. Steve Oma. He's the Vice Chairperson of the National Steering Committee on Implementation of Alternative Justice Systems Policy in Kenya. So, Dr. Steve, the Kenyan experiences are often quite unique. It's a diverse country. It's a country full of different nuances when it comes to addressing justice and any other matters. So could you help us understand a little bit what is distinctive about Kenya's approach to accommodating customary and community-based justice actors within the broad alternative justice systems policy, and how did that come about? Steve, the floor is yours. You have 5 minutes.
Nope. Oh, yes. Okay, thank you. I got it. So thank you very much, Chair, and to all of you. I think 3 things make Kenya's experience very distinct. One is that our idea of what we call alternative justice system is rooted in a creative interpretation of the law. So we looked at the Constitution, and we looked at the provision on access to justice for all, and then we asked how. And then when we looked at how, we asked our question, whose reality counts, as Robert Chambers would say. And in the reality, we realized that a significant portion of justice intervention, access to justice is done through mechanisms rather than the court. So what we did, therefore, was to look for mechanisms of reinforcing the options that people had taken. But in doing that, we did another creative thing. We made sure that what we call alternative justice system is not alternative because they are backward, they're evolving, or subordinate, but they are called alternative because the default system, the one that has got a door for everybody, is the judiciary. So then we drew a system of relationship where the judiciary formed one among many doors of justice. So this is really the idea of the multiple doors of justice, so that then you have judiciary people can, as you put in the example, can go to the elder at the corner, can go to the pastor if they want, can go to the sort of the paralegals and so on. And that's a complete reversal of the colonial architecture of a state-based justice system. Because the colonial architecture of state-based justice system had the idea of plural institutions, but they were placed in a hierarchy where non-court system was seen to be evolving to be like the court. But what we did now is to situate all of them in a similar pathway of action, so that then if you go to court, you are not deprivileging those who go to paralegal. If you go to the Women's Guild, you are not deprivileging those who go to the elders. The final thing that makes Kenyan experience very creative, and that is something that Justice Madeka mentioned, is that already in the year 2005, we had established what we call the court user committees. At that time, the court user committees were mainly for the state-based, mainly criminal-based, criminal justice actors, police, probation, the judiciary, prosecution, and so on. But within this new rethinking of transformation, we reorganized our court user committees to include all stakeholders, so that then, although judiciary is a default institution in terms of the one that should ensure access to justice for all, the delivery of justice is the role of all stakeholders. And you know what that means? It means that you cannot just talk about justice seekers on one hand and justice providers on the other hand, because now you relate to them using a human rights approach, where a justice seeker tomorrow can be a justice provider. And that change is fundamentally important, even in thinking about how the state designs itself and relates with the people. Thank you.
Thank you very much, Dr. Steve. This has been really inspiring. And honestly, I think that the Kenyan experience is also in bringing traditional justice methods into parity with the institutional justice methods. I think this is quite inspiring and an innovation for the continent. Let's move a bit closer to home. We have here the honor to have Justice Omar Seka, the chairman of the Kadi Appeals Panel here in the Gambia. Justice Seka, how does Kadi courts in the Gambia engage with other forms of justice? For example, is the magistrate courts or the district tribunals, how does that work on the Kadi courts, and how does this contribute to reducing conflict and promoting cohesion in Gambian communities? Can you please draw a little bit on these experiences for us? Thank you.
Thank you very much, Madam Moderator. In the Gambia, we have 3 parallel systems in the judiciary. Conventional courts that prepared and established by the colonial. And before colonial came, there was traditional justice being prevailed by the community leaders. These traditional were matched with Sharia law, because Gambia is predominated by Muslims. 97% or sometimes 96 are Muslims. So that's why traditional rulers, they were applying Sharia, because their traditional were derived from Sharia. So when the colonial came, they divide country into 2. What they call protected area, they leave them continue prevailing the justice system they were applying before colonial. And the colonial area is towns, Banjul and others, they were fully adopted by colonial justice. Except the people of Banjul those days, Batos, the capital, the elders, Muslim elders, requested from the colonial to be allowed to adjudicate their personal matters according to Sharia, which was allowed to them since 100 years ago. That was about 1906. From there, the first Kadi court was established and was working alone at Banjul. Muslims were adjudicating their matters concerning personal laws to that court. After was there was another court established at Carnifing. These two courts were there throughout of the colonial days, and it was also throughout of the First Republic. The Second Republic, with the Ajami system, they bring off a new constitution, 97 constitution, which allowed this Kadis court to be established anywhere in the country. Now our Kadi court, we are dealing with Muslim personal law. These have their own jurisdiction dealing with inheritance, Muslim inheritance, and marriage and divorce, custody, child custody, extra. So nowadays, our courts are contributing immensely in reducing the backlog of the case in the conventional courts. Also, we have still retaining our customary courts dealing with the local leaders, chiefs, and alcalos. These local leaders, their jurisdiction is wider than even the Kadi court, because the Kadi court only limited in these three areas. But the local leaders, they can adjudicate the area dealing with Sharia matters. But nowadays problem that our local leaders are not longer versed in Sharia law. That's why when we establish our Kadi court in all regions of the Gambia, they're now referring their old cases to the Kadi courts based on the public confidence on these caddies that they can adjudicate these issues better than the local leaders. Even the public get trust more than the caddies in terms of public Muslim personal law than even the other courts. Yes, this is the fact in the Gambia. So nowadays in our Cadiz court, I could remember the year before in our legal system, judicial legal how to call it, legal year, Chief Justice announced that the lower courts in the Gambia, their case were about 4,000 cases in the year, to 5,000. Cadi courts, they were having more than 2,000 cases from it. So this shows us how the Cadi court contribute to reduce the load of the other courts in the country. And also other significance that we have in our Cadi courts. We have what we call fast track procedure. Our procedure is very fast. It's not long. It's not very complicated like conventional rules. We have very short rules, very simple, and the case we can hear it one day and finish it. 1 week we finish it. So that's why people feel, even the lawyers also feel to come to our court in order to earn their money easily and very fast. So this is the significant area that we have in our courts. In terms of contra jurisdictions, we don't have that much more like that we have with children courts. Okay, that is not caused by the law, by the court itself, but it caused by the act. Children Act doesn't mention specifically that the Cadiz court doesn't longer have maintenance and custody. Now, still now, when we end the marriage before the Cadi court, we do deal with the child maintenance, and we do, because this child maintenance is among the consequences of divorce. You cannot take divorce matter and decide, then leave its consequence. We include the right of the husband and right of the wife and right of the child emanate from this marriage. So nowadays our court really contributed a lot in terms of reducing the load of court and the BC that people have in other courts. And our court, in our Kadi court, having good relation with other court, like magistrate court. Just like I said, we don't have any. We have inter-training. We are training together now. For example, the enhancing capacity building of the judicial officers, CADIs are involved. We are fully integrated in those capacities. Many training sponsored by UNDP and other international organization CADIs are benefiting from those training, really. And recently, I joined last month in the CNJ training, and I present a paper there. This also shows how the CADI score are integrated in the system today. Thank you.
Turn off your mic, please. Thank you very much. Thank you. This has been this has been an interesting comparison so far. But I've heard from what you said the importance as well of and how has it been building trust, enhancing confidence in the systems, but also providing agility. Huh? I mean, like working on the backlog. This is extremely important in making sure that people decide to come forward, and if they decide to come forward, they can take the means of justice that they find and then they're more comfortable with. We're moving a little bit out of the Gambia at the moment. We're moving to Mali. We have Mademoiselle Aisha Diarra. She's the project manager of WILDAF Mali. And we're going to discuss about grassroots organizations, which in the morning we heard the importance of engaging with civil society and keeping civil society afloat in matters of justice. So my question to you is that how has justice defenders, human rights defenders, helped people claim their rights? How have you engaged in your capacity as civil society, engaged with customary justice actors, and how does that differ from the work that you do with them with traditional justice actors? The floor is yours.
Merci de m'avoir donné la parole. Bonsoir tout le monde. Vous avez Madame Aïcha Bourama Diarra, je travaille à l'ONG WILDAF. WILDAF est un réseau d'associations et d'ONG de promotion et de la protection des droits des femmes et des enfants. WILDAF a été créé le 3 mars 1995 dans le but d'une instauration d'une culture d'exercice et de respect des droits des femmes et des enfants au Mali et en Afrique. Nous offrons des services tels que la formation et assistance technique en matière d'éducation juridique. Nous faisons le monitoring des violations des droits des femmes, système de réponse rapide. Il y a la production d'outils et de manuels de formation et de plaidoyer. Il y a l'organisation de campagnes de sensibilisation et d'information centrées sur des thématiques telles que les thématiques des VBG, les thématiques des violences sexuelles et conflits, la médiation et entre autres. Nous faisons aussi la prise en charge juridique et judiciaire et psychosociale des victimes des violences basées sur le genre. La question qui m'est posée, c'est comment les défenseurs de la justice de proximité aident-ils la population? Avant de répondre à la question, permettez-moi quand même de faire l'historique comment le parajuridisme a vu le jour au Mali. C'est dans les années de 1991 que le Mali a connu un soulèvement populaire réprimé en mars 1991, suivi d'un coup d'État militaire qui a instauré une transition démocratique, voire également le début de la rébellion Touareg avec des événements notables tels que les accords de Tamarasek. Le processus de démocratisation et l'édification de l'état de droit enclenché au Mali depuis 1991 ont permis de réaliser les avancées sur le plan institutionnel par la création d'institutions démocratiques et l'organisation périodique des élections. C'est dans ce contexte marqué par l'émergence de nouvelles institutions démocratiques, le taux élevé d'analphabétisme, la faible connaissance des populations sur leurs droits et devoirs. La méconnaissance des mécanismes et l'ignorance des procédures juridiques sont autant de facteurs qui constituent des obstacles à l'enrichissement du processus démocratique au Mali. C'est pourquoi, depuis 1991, des structures de la société civile malienne ont décidé d'apporter leur contribution aux côtés des actions de pouvoir public. Il s'agit d'aider des communautés à la base, de s'approprier des processus par la formation, la sensibilisation, les causeries débats, et entre autres. Il faut comprendre que l'identification de ces parajuristes, il y a des critères. Et ces critères, il faut être originaire et résident dans la communauté d'intervention, être disponible pour fournir les services à la communauté en tant que parajuriste, disposer d'une maturité suffisante. Nos parajuristes l'âge commence à partir de 25 ans. C'est 25 ans et plus. Et ces parajuristes, ce ne sont pas nous qui travaillons au sein de nos structures que nous choisissons ces parajuristes, mais c'est au sein de la communauté. Nous partons voir les chefs du quartier, la chefferie traditionnelle, c'est eux qui décident de qui ils vont choisir pour que cette personne puisse recevoir la formation pour être parajuriste et donner des informations et être des relais des différentes structures pour quand même informer la société sur leurs droits et de leurs devoirs, faire la prévention au cas où si l'infraction doit être commise dans les différentes communautés. Et il faut savoir que ces parajuristes doivent au moins minimum savoir lire et écrire. Et ces défenseurs de parajuristes, il faut comprendre que ces parajuristes jouent un rôle de passerelle entre la population locale et les institutions judiciaires formelles. Donc, leur mission, comme j'avais cité entre autres, c'est d'informer les citoyens sur leurs droits fondamentaux. Les parajuristes assistent dans la résolution amiable, c'est-à-dire en cas de médiation, en cas de conciliation, s'il y a un conflit qui surgit au sein de la communauté, ces parajuristes sont impliqués. Ces parajuristes orientent les victimes ou les justiciables à la justice. Parce qu'il faut comprendre que dans la communauté malienne, des fois les femmes accouchent, les enfants n'ont même pas un acte de naissance. Il faut savoir que dans la communauté malienne, les femmes ne maîtrisent pas totalement leurs droits. Et dans cette communauté, un homme peut chasser une femme et s'il s'agit maintenant d'aller au tribunal, la femme n'a pas de preuve. Et au niveau de la justice, nous savons très bien que c'est la preuve que le juge voit. Et là, la personne est considérée comme étant en abandon conjugal. Et quand tu ne connais pas ses droits, forcément, ça sera compliqué. Et le rôle de ces parajuristes, c'est de sensibiliser. Ils sensibilisent la communauté. Et ces parajuristes travaillent en étroite collaboration avec les leaders communautaires. Parce qu'il y a la formation de ces parajuristes qui sont là sur les b.a.-ba des instruments juridiques. Parce que comme je lui ai dit tantôt, ce ne sont pas des juristes, mais c'est des personnes qui savent écrire et lire qui sont au sein de la communauté. Donc, ce ne sont pas des juristes. Et chaque 6 mois, ces parajuristes, si nous avons des fonds qui permettent de renforcer ces parajuristes, nous les renforçons pour qu'eux aussi puissent renforcer la communauté. Et il y a aussi le renforcement aussi des leaders communautaires et religieux. Et ces leaders communautaires, pourquoi nous renforçons ces leaders communautaires et religieux? Parce qu'au sein de la communauté, quand les gens ont des problèmes, ils se réfèrent directement à cette communauté. Ils se réfèrent directement à ces leaders communautaires et religieux. Parce que la population a tendance à rejeter la justice formelle. Ils pensent qu'au niveau de la justice, on ne dit pas la vérité. Mais alors que ce qui est dans le code pénal, ce qui est dans les instruments juridiques, les personnes ne maîtrisent pas comme il le faut. Donc, il y a cet obstacle qui est là et qui est une barrière entre la population et la justice formelle. OK. Et dans notre contexte, dans mon propre contexte, pour interagir directement avec les acteurs de la justice coutumière, bien sûr, moi, j'agis directement avec les acteurs coutumières. Comment j'interagis à travers les différentes formations que je viens de citer, à travers les différentes sensibilisations que je viens de citer. Et ces leaders communautaires, il faut comprendre que nous ne travaillons pas seulement qu'avec les musulmans, mais nous travaillons aussi avec les prêtres, nous travaillons aussi avec les traditionalistes. Donc, Wildaf et la société malienne travaillent avec ces personnes-là pour que au moins ces personnes, comme on appelle les victimes, les survivantes qui sont au sein de ces communautés, puissent au moins quand même avoir leurs droits, le minimum de droits fondamentaux que ces personnes ont besoin, donc raison pour laquelle les leaders communautaires, les parajuristes sont renforcés pour qu'ils puissent aider au retour cette communauté qui sont marginalisées. Je vous remercie.
Merci beaucoup, Mademoiselle Aisha. Extremely interesting to see, and I particularly appreciated the emphasis and the focus given to rights holders, to survivors, to the people. You did mention in the beginning about the role of paralegals, and that's the journey we're taking with our next speaker. Ms. Yusfa Abdallah Said, she is the head of division for legal aid management in the Department of Constitutional and Legal Affairs in the government of Zanzibar in Tanzania. Zanzibar is notable for working to strengthen linkages between legal aid providers, community-based mechanisms, and the formal justice systems. What are the promises, what are the innovations that you have anticipated, and what can other African leaders learn from the experiences of Zanzibar in integrating legal aid providers, community-based systems, traditional systems, and so on? Could you walk us through a little bit how the journey of Zanzibar has been?
Thank you, Madam Moderator. As I was introduced, I am from Zanzibar, United Republic of Tanzania. In Zanzibar, access to justice is achieved through a variety of formal and informal justice pathways, reflecting the unique legal, cultural, and social context of the island. These pathways collectively contribute to ensuring that all citizens, especially the vulnerable and marginalized groups, can seek redress, resolve disputes, and uphold their rights. So, for the purpose of making sure that in Zanzibar no one is left behind, the revolutionary government of Zanzibar established the Legal Aid Department in 2019. The department falls under the formal justice pathways. So when I go to my question, how is Zanzibar working to strengthen linkages between legal aid providers, community-based mechanisms, and the formal justice systems? And what promising innovations or lessons can other African countries draw from your approach to people-centered justice? Zanzibar has made significant progress in strengthening the collaboration between legal aid providers, community-based structures, and the formal justice systems to ensure a more inclusive and people-centered approach to justice delivery. One of the notable strategies has been the institutionalization of paralegal services within communities. Paralegals serve as the first point of contact for many individuals seeking justice, offering preliminary legal advice, mediation, and referral to formal institutions such as courts, police, or social welfare officers, and sometimes to the department, the legal aid department. So the role has proven instrumental in linking grassroots justice in needs with the formal legal framework. Also,
Legal department works closely with the judiciary, the Office of the Director of Public Prosecution, the Ministry of Community Development, the police, to mention a few, to strengthen coordination mechanisms. Regular multi-stakeholder forums and legal aid networks have been established to enhance information sharing, referral efficiency, and accountability among justice actors. There's the multi-stakeholder forums includes the in Zanzibar, the legal department will always prepare. We have the legal aid week. We have the annual legal aid forum. We have the refresher courses for CSOs. All these events has one aim of bringing together different legal aid stakeholders and strengthening coordination mechanism. In addition, community outreach and mobile legal aid clinics have been introduced to reach isolated communities. In Zanzibar, we have 2 legal aid clinics. They're all from the universities and centers that provides law studies. One is from the University of Zanzibar, and the second is at the Law Resource Center, whereby students of law faculty act as legal aid providers to their fellow students and to the neighboring community. These initiatives not only extend legal services to marginalized populations, but also foster stronger relationships between legal aid providers and community-based structures. We talk about the lessons and innovations from Zanzibar approach to that other countries can draw upon, include the community-anchored legal aid models that empower legal paralegals to bridge the justice gap at grassroots level. We empower paralegals. We provide we always refresh them by giving them refresher courses and make them be aware of what has changed when it comes to legal framework. What are the laws that maybe have been amended or have been things like that. Government-led coordination through a centralized legal aid department that standardize quality, ensures accountability, and supports sustainability. Also, the integration of formal and informal justice mechanism to promote culturally appropriate, timely, and affordable dispute resolution. And overall, Zanzibar's experience underscores the importance of holistic people-centered justice system that places communities at the heart of the legal empowerment. This integrated approach continues to strengthen trust in legal institutions and advance the goal of leaving no one behind in the pursuit of justice for all. Thank you.
Thank you very much, Yusfa. I have personally visited the legal aid units in Zanzibar with the UNDP team there, and it's really inspiring to see especially how empowered the paralegals are and how close to the community they are. So they are indeed the ones that are seen sometimes even preventing conflict from happening. That's quite inspiring. Okay, to my fellow panelists here, we have to make an agreement. I'm going to give you 4 strict minutes for your question, for my second round of questions, in order for us to have a second round. Would that be okay? And if you're going beyond your 4 minutes, I'll do a very gentle nudge, very politely, just so you can wrap up your comments. Is that okay? Because we want to have space for a conversation. So we're going to take 1 minute from each in order for us to have time for conversation today. So my second round of questions, we're going to go a little deeper on some of the issues and also rely on your expertise to ensure that we have enough meat for our discussion later. So for Dr. Steve, a little bit again on the alternative justice system policy and the practical implementation. Has it strengthened the trust that Kenyans have in the overall justice system provision? And how does that, perhaps you can make it a reflection, how does that relate to trust in the state more broadly? Over to you.
Thank you very much. And that question is very important because we need to engage the question of access to justice as a governance issue. It's a governance issue. And I remember in the year 2010, a delegation from South Sudan came to the Judicial Training Institute, with whom I've been attached for many years now. And they were asking us to help them to move from an Arab-based system to an English-based system. They said Arabanization has caused distrust between the people and the state. And so they thought that an English-based system, the common law system, would be a better idea. We told them we are also running away from the English-based system because we think neither the Arabanization nor Englishanization is a solution. So alternative justice system, therefore, is a practical tool that has helped in re-enhancing the trust between the state and the citizens for two reasons. One, if you look at Kenya, the regions where alternative justice system worked for long and were neglected were also regions that were seen to be either in the political opposition or not part of the compliant state, the northern parts of the country. So by then giving a name to their method of justice and allowing that method of justice to interact with the state, that was the first step to start enhancing this trust building. Secondly, the way we have done our implementation is through developing what we call county action plans, where in every sub-national zone, which we call counties, we are developing action plans by mapping the justice issues there and then use those justice issues to develop a model that can be used to advance access to justice. And I'm happy that my brother, Dr. Ambua Kitucha Sheria, just funded the development of one we recently launched in Mombasa. And in Mombasa, for example, one of the challenges was with the youth and a movement that was talking about secession. And the county action plan sublimed the question of secession. They say, now we can't talk about secession. We're talking about our justice issues and how to have a conversation. So that's the county action plan is a practical strategy that we're using in each county. And our vision is to have that reach every county in Kenya by the year 2029. Finally, is alternative justice system is a tool of decolonization. The colonial state had the idea of plural justice system, but they governed it through what we call a risk-based method, where difference was seen as a risk. And so it was governed as something that needed to be controlled. And that's why the repugnancy clause was very important in the colonial jurisprudence and colonial governance model, because pluralism was a risk. However, in the current regime, the pluralism is governed through a right-based paradigm, a human right-based paradigm. In the human rights-based paradigm, there is the right to be different. So being different is no longer a risk, it's a right that is protected. In fact, our constitution, both in the preamble and Article 27, is really about protecting difference. And AJS protects difference. So in that way, therefore, when you practice differently, when you conceptualize the world differently, when you feel justice differently, the state that no longer sees you as a risk, no longer sees you as deviant, no longer sees you as resisting. It sees you as an actor within a plural setup who needs to be accommodated. So this shift from risk-based governance to human rights-based governance is a major contribution that we have given, and also our approach of county action plans, which then root justice issues in the local situations and the worldview of the people. Thank you.
Thank you very much. And with some time to spare, great. It's indeed a unique one, a human rights-based paradigm shift, and the right to be different, and the shifting model within the legal system and within your legal frameworks. That's extremely interesting. Talking about human rights as well, we're going for just a second. We are meeting here on the sidelines of the ordinary session of the African Commission on Human and People's Rights. that happens, that serves the continent, but happens to be based in your country, the Gambia. Can you talk about how the Cadi courts in the Gambia ensure people's human rights are defended? And also on the African Commission on Human and People's Rights, as an institution, have they been relevant to your work and in which ways? Over to you.
Of course, yes. And our Cadi court works protecting human rights, because in Sharia that we are applying, Sharia is for protecting human being. Before going on to the detail, I want to inform you that Sharia objective in all injunctions centered in 5 pillars. Number 1, to protect religion. Number 2, to protect intellect. Number 3, to protect properties. Number 3, to protect lineage, people lineage, and others. So you cannot protect this area and violate human rights. This is because to protect people religion, have freedom of religion, protect your intellect. That's why toxicant and others is forbidden in Sharia, because in Sharia concept, this mind is not for you alone, it's for human being. You don't have right to destroy it. So that's why in our Cadi court, we are applying fair hearing, which is fundamental rights. We are protecting women in our court. They have right to come and they have right to also to be represented. If in our constitution, we mentioned that the people coming to the Cadi court in the Gambia, they have right to be represented by their own cost by a person qualified in Sharia. So now the lawyers coming. Here we have little problem where we don't have very vast lawyers in Sharia. But nevertheless, there are many training were conducted to elevate lawyers' knowledge in Sharia. Recently, before 2 months ago, there's a female lawyer association conducted training for the female to allow them to enhance their capacity building in Sharia area to able to represent vulnerable people like women and children. Also, our area of protecting human rights, we are ensuring we are securing the right of child and women together when divorce take place, because these are the area mostly problem arise where divorce take place. Who's supposed to take the children? Who's supposed to have right of custody? Who's and so. So our basically we are working on the best interest of child. The best interest of child. If the court says that the best interest of child is to live with her mother, we will apply that. If to live with the father, we will apply that. If to live with another parent, also we apply that. So this is also protecting child rights. We are also securing marital rights. It's no longer here in the Gambia. Now we have what forced marriage. There are no forced marriage now in the Gambia. The court are open every day. If somebody feel are forced to be married, you can come to the court, and the court look at it. If not correct, the court can dissolve it. Also, we have where this refusal of intermarriage of intertribal marriage. Sometimes some tribe doesn't allow other tribe to marry their daughters like that. Also, it's no longer applied in the Gambia. The girl can come to the court, can stand to the court and sue her father that she or he refused, allowed her to marry. So the court used to marry her for that also guy she want to marry. Also, our court applying equitable principle in case management. As I said earlier, our course we call our procedure a fast track proceeding. It is what also to inform you that in the Kadi court, 2 out of 100 years there was no rule of proceedings. During my tenure in this position, I was able to bring rule of proceeding for the lower court and the court of appeal for the Kadi appeal panel. These rules, I finished everything. Many things remain. In next, inshallah, in next session.
Do wrap up, please. Thank you.
Thank you very much. Okay, you want me to complete?
Yes, do complete, of course.
1 minute. No
1
problem.
minute, yes.
Really, we are respecting human rights. And also, we believe that the commission, we have relation with them. Because the commission is about to regulate the human right in Africa. And this human right also is speculated in our constitution. And the Kadi court working under the constitution of the country. So that's why we have relation. Also, we hope the commission may sponsor more training for the people working in the Kadis to familiar more about its area to consider it in our work. Wassalamu alaikum warahmatullah.
Thank you. And apologies for being strict. I promise I just want us to have more time for discussion and from the people from the floor to interact. So, Ms. Aisha, we heard from Justice about as well the importance of having justice in a very people-centered way. He did mention addressing the needs of the people and giving exactly updating and giving the real needs of the people. So my question to you is, given an overview of an African context, what do you believe is the approach for strengthening access to justice in a more context-specific, fit for purpose in this continent? How would you see an African approach to people-centered justice? 5 minutes. Can you turn off your mic?
OK. Pour renforcer l'accès à la justice en Afrique nécessite une démarche adaptée en réalité sociale, culturelle et institutionnelle locale. Une approche contextuelle doit être articulée dans plusieurs dimensions. Il faut valoriser les systèmes judiciaires, coutumières et communautaires. Dans de nombreuses sociétés africaines, la justice coutumière est le premier recours pour résoudre les litiges du quotidien. Elle repose sur des valeurs profondément ancrées. C'est dialogue, conciliation, respect de la hiérarchie sociale et restauration du lien social. Une reconnaissance juridique encadrée des instances traditionnelles. La formation des chefs coutumiers aux droits fondamentaux. La mise en place de passerelles entre justice et tribunaux étatiques. Pour développer une justice de proximité, beaucoup d'Africains vivent très loin des tribunaux, n'ont ni les moyens, ni le temps de s'y rendre. Une justice adaptée doit donc être décentralisée et accessible, par exemple, via des maisons de justice, au centre d'assistance juridique et communautaire. Des procédures simplifiées et gratuites pour les litiges mineurs. L'utilisation des langues locales pour les audiences et les documents juridiques. Une justice doublée de visage, c'est-à-dire formelle et coutumière. Si je prends l'exemple du Mali, le Mali dispose, comme beaucoup de pays africains, un système juridique pluraliste. D'une part, la justice étatique moderne, inspirée du modèle français. D'autre part, une justice coutumière communautaire profondément ancrée dans la pratique locales. La plupart des Maliens, surtout en milieu rural, continuent de s'adresser aux chefs de village, les cadis, les imams, au conseil d'anciens pour résoudre leurs différends. Ces instants privilégient le dialogue et la médiation, la persévération de la cohésion sociale. Avant de clôturer, j'aimerais quand même faire des recommandations. Ces recommandations, c'est de renforcer l'articulation entre justice coutumière et justice formelle. Et reconnaître officiellement les mécanismes coutumiers de résolution des conflits tout en définissant un cadre légal clair pour éviter les abus. Je vous remercie. J'ai été très rapide.
Excellent. Indeed, harmony, finding a harmony between the systems, working in dialogue, mediation, acknowledging the existence of some of these systems. This is extremely important in making sure we provide an African fit for purpose, people-centered justice. So, Yusfa, from your experience leading legal aid services in Zanzibar, when thinking about adjusting that to the real needs of the people, some of the more vulnerable groups, especially women and youth, are often the ones that face higher barriers in accessing justice. So how has the legal aid framework in Zanzibar helped people overcome this challenge and access to justice more effectively?
Thank you once again. From my experience working under the legal aid department in Zanzibar, several key barriers continues to hinder ordinary citizens, particularly women and other vulnerable groups, from effective accessing justice. Firstly is limited legal awareness. This challenge remains to be a major challenge, whereby many citizens are not fully informed about their legal rights or the procedures of seeking redress from formal justice institutions. This lack of knowledge often discourages them from taking legal actions, especially in cases involving family disputes, gender-based violence, and inheritance matters. Secondly is the socio-economic constraints. The socioeconomic constraints play a significant role. A large proportion of vulnerable individuals, especially women in rural areas, cannot afford legal representation or the transportation costs associated with attending court sessions. So this economic hardship makes justice appear inaccessible and sometimes irrelevant to their daily realities, and makes them, some of them say that they leave it to God, as they believe that God do punish the wrongdoers. Thirdly, the cultural and social barrier persists, particularly gender norms that discourage women from reporting abuse or asserting their legal rights. In response to this, the Zanzibar Legal Aid Framework under the Legal Aid Act number 13 of 2018 and its regulations has provided a structured approach to overcoming these challenges. First, the decentralization of legal aid services through the recruitment of and deployment of community-based paralegals across Unguja and Pemba to provide first-level legal assistance and referral services. Secondly is the public awareness campaigns and community outreaches. These legal awareness campaigns aimed at educating citizens about their constitutional rights and available legal aid services. For example, a few months ago in Zanzibar, we were implementing the Mama Samia legal aid campaign. This campaign was implemented in all districts in Zanzibar, meaning Unguja and Pemba, and a total of 422,908 citizens received and access to legal aid services, where 9,185 were women. During this legal aid campaign, the department ensured that every citizen in both Unguja and Pemba had access to legal aid services. All these efforts reflect the commitment of the government of Zanzibar to ensure that all people, especially women, children, and vulnerable groups have access to legal aid services. The other is the collaboration with the civil society organizations and the women-focused NGOs to ensure that marginalized groups receive target support, including psychosocial counseling and legal representation. The organization here are like the Zanzibar Female Lawyers Association, the FELA. We have the Zanzibar Law Society. We have the Zanzibar Legal Services Center and the Zanzibar Legal Aid and Human Rights Organizations. We also work together with the paralegals, as I mentioned before. The other is the integration of alternative dispute resolutions mechanisms, such as mediation, within the legal aid framework to promote timely and culturally sensitive resolutions to community disputes. So through these interventions, the legal aid framework in Zanzibar continues to bridge the gap between the formal justice system and the lived life realities of ordinary citizens, particularly those who have historically have been excluded from the justice process. Thank you.
Much. Wonderful. So now it will be a good time for us to, we have heard experiences from Kenya, from the Gambia, from Mali, from Zanzibar, diverse experience, diverse and different pathways of achieving justice in different jurisdictions, different ways of handling, talking to civil society, to people, adapting, making sure that justice is made closer. So we would like to open the floor now for reflections, comments, examples that you may have, or direct questions that you may have to the panelists. Please keep your contributions brief. I may time you, and if you hear me, it's for you to go to the point, okay? We have a deal. So Mercedes has the microphone. Over.
Hello, good afternoon, everyone. I am Abi Rachel Ogonyasi from the Gambia. Okay, I just want to acknowledge, based on the key success stories that have been shared by the representative of Mali concerning WILDAF, my question would be, what is WILDAF doing in ensuring that the voice of single mothers in Africa, it's been heard? Thank you.
Next.
Thank you so much. Should I stand up? Okay. Good evening, everyone. My name is Sharon Truzão. I come from Mozambique, representing Women Law and Development, women's rights NGO in Mozambique. So I think I'm finalizing with a comment because this was a very interesting day with very interesting discussions. And now I think we gave a very good final tone to our forum, because I believe people-centered justice should be accessible, inclusive, non-discriminatory, specific to the African context, and we must eliminate mob justice. Mob justice because people don't feel that they can go to the right mechanisms to find justice. It means our role as NGOs, as governments, as legal institutions, we must cater to the fragilities of these institutions to ensure that the people really take place at the center. I would even say placing is not the correct term, ensuring that they own their place, their space as right holders. So eliminating mob justice is our very own approach as Africans to place justice at the center, and ensuring women, children, people, indigenous communities, they don't feel left out, but still a part of the change that we're trying to create. Thank you very much.
Muito obrigada. The next one. Mercedes, maybe we go to the other side first and then we come back to this. Yeah. So unfortunately, I did not see who raised the hand first. So he's on my eyesight. So the gentleman in the middle there, next to Lara. Next to Lara. Yeah. This room does not give me visibility, so it's been a bit arbitrary. So please go straight to the point.
D'accord, merci beaucoup. Alors, je voudrais d'une part donc saluer en tout cas l'ensemble donc des contributeurs et évoquer la question par exemple donc justement de la médiation pénale qui a été expérimentée donc au Burkina Faso, basée sur d'ailleurs donc une étude qui a révélé que la plupart donc des affaires étaient réglées d'abord et avant tout par des chefs coutumiers. Et nous avons parlé d'ailleurs de preuves, de données probantes, du moins qui devaient soutenir justement les interventions donc, en matière donc, de justice. Et sur la base de cela, Terre des Hommes donc, a expérimenté donc, une démarche donc, de médiation pénale qui a consisté d'abord donc, à renforcer les capacités donc, des médiateurs pénaux coutumiers, représentés donc, par les chefs coutumiers, et ensuite à travailler donc, avec les procureurs, les parquets, à la fois de Ouagadougou, mais aussi de Bobo-Dioulasso, donc dans une démarche donc, expérimentale. Et cela a donné des résultats probants. Et parce qu'il y a certes la nécessité donc d'impliquer des chefs, mais vous savez que souvent donc la tradition n'est pas toujours respectueuse donc des droits et en particulier donc des droits des enfants. Et ils n'ont pas non plus donc une méthodologie donc pratique donc de la médiation qui soit cohérente donc avec les questions donc des droits de l'enfant. Et donc en renforçant donc leur capacité, on a donc permis justement donc de produire donc du résultat concret. Et actuellement, nous sommes en train donc d'expérimenter cela donc aussi, d'engager cela dans le cadre donc du projet de l'AIFA au niveau donc de la Guinée avec une volonté politique donc réaffirmée d'aller dans ce sens. C'est ce que je voulais donc apporter donc comme contribution.
Merci beaucoup. Okay, this gentleman here, he was faster, and this lady here, and then we're going to go for the first round of responses. Okay.
Good afternoon, or must I say good evening?
Maybe.
Thank you very much. My name is Samba Jao. I'm from the Gambia, representing the International Center for Transitional Justice. My question is directed towards my fellow Gambian force. Being aware that the Gambia operates a pluralist system of governance, or the legal system, wherein we have the Sharia law, statutory laws, and customary law in practice. How do you think access to justice can be harmonized, given the fact that we all know there are a lot of confusion sometimes as to what the statutory law says versus what Sharia says and versus what the customary law is saying? The second question might be a question or a comment. It goes to all of the panelists. I think by access to justice, we mean to see a lot of principles embedded in it. First and foremost, we know that in the context of the Gambia, for example, if you want to study law, you're going to pay 100 and something thousand. Okay, the farmer in the rural village don't even know where to start a case. And we're talking about access. You go to any chambers to look for a lawyer or legal advice, you will be paying almost one of your year's savings to get advice. So I don't know whether there should be a need to even start making sure even lawyers don't charge certain fees to people who are in conflict with the law. I know it do not be something that is nice to hear, especially if you are a lawyer in the house, but we always complain about high commodities of prices in the market is not regulated, and so on and so forth. So thank you, I'm being goes on.
Thank you. Okay, so if the two of you, lady there and you here, keep to very brief, you both can share the time, okay? And remember, a question ends with a question mark, okay? So you're welcome to make comments, but focus on question mark.
I can go. So just very quickly, from listening. Okay. Yeah, the people-centered justice goes with legal empowerment. And listening to everything that has been said, it's just further reinforced that community-based paralegals play a very keen role in this work. But we also need to ensure that there is inclusion of women and persons with disabilities because they also are a marginalized group that we tend to just lump everybody together, especially in our context. The Gambian, from where I come from, sorry, my name is Amina Hanga from Nigeria. It's from the part where we come from, it's Islam, and women are not really wanted to be seen in the public sphere so much. So how do we ensure that we take a gendered approach to people-centered justice, and also in bringing in legal empowerment into it, because the two go together and we cannot separate them from all the discussions that we've been hearing.
Thank you for sticking to the point, and that's for you now.
Thank you. My name is Leonie Mutoni. I'm from Rwanda, and I'm representing the African Center of Excellence for Access to Justice. I want to thank the panel for their rich insights on this very interesting topic. My question goes to Dr. Steve. I admire how Kenya is one of the African countries that have formally recognized community justice systems, including community-based paralegals, as your 2016 Legal Aid Act very clearly recognizes them as legal aid service providers. And CSOs in Rwanda, we're trying to do the same. We're advocating for formal recognition. And there is political will because the government is promoting ADR as one of the effective ways to deal with case backlogs and also prison overcrowding. And my question is, in the Kenyan experience, what were some of the key or effective strategies that helped in formally recognizing community-based paralegals? Thank you.
Thank you very much. And I feel like a terrible parent, you know, when the children are looking at me asking for something and I cannot give it back to you. Many of you are locking your eyes at me. Please give me the floor. Unfortunately, I have received clear instructions to end the session at 4:30, but I'm also very, very excited that this topic, even at the end of the day, has brought so much attention. It just proves the relevance that it has and the need for more spaces like this for discussion. So without further ado, I'm going to give each of the speakers 2 minutes to give your concluding comments and also your reflections based on the many questions. And I hope in the reception network cocktail we have today, you have the chance we can discuss more about that. But Dr. Steve, first to you.
Thank you very much. And I think the comments were very generous. To start with, how have we been able to have such a rich tapestry of actors recognized by law? We are lucky about history. I hope you know that Kituo cha Sheria was established in 1973. So we have had a long history of people's struggle that the state can no longer ignore. And we've made sure that that history is now fortified in law. So any law we establish in Kenya, if you look at even our constitution, it's long because it's a very historical document. Now the next stage, therefore, is how to unbundle how paralegal works. And we are telling the state the role of the law is not to control paralegal, is to promote paralegal. And there's a difference between control and promote, because we believe that that independence is part of what fosters access to justice and sustains people's freedom to choose. I agree it must be engendered, and gender, where the principle is about inclusiveness. So we have engendered persons with disability, minority, and many other people who find themselves in vulnerable and marginalized positions. But allow me to make one important last comment, which also captures much of what has come through, which is, which kind of matters go to the AJS forums? We have confronted openly the common law logic that used to argue that criminal matters go to courts, state-based courts, and civil matters go to AJS. And we think that division is wrong, is fictitious. And we have established a new framework of what goes to AJS forum. And we say that any matter which is not prescribed by law, the law does not say no. For example, a child-related matter cannot go to AJS forum because a child cannot choose. Defilement cannot go to AJS because the law is clear that that must be solved through the state-based courts. However, other matters such as even what one may consider to be a criminal matter, including murder and manslaughter, can be resolved through AJS. And that happens when you see AJS and state-based courts as a continuum, not parallels that exist in isolation. So this continuum logic has really helped us to make sure that we continuously strengthen people's choices of forms of justice, but also advance a legal practice and a justice practice that does not leave anyone behind. And finally, Chair, the lawyers. I think it's a very important comment, but we have to be careful with it. We were already told in the morning here by my brother that health is not only found in hospitals. Education is not only found in schools. We've been learning here. This is not a university. So a legal-centric idea of justice will be a problem. So yes, we need to make access to legal services affordable. We are doing that. However, legal-centric, court-centric approach will take us behind. So lawyers are one of the avenues of accessing justice, just like medicine men, rainmakers like me, women in the guilds, and so on. Thank you very much.
Thank you, Dr. Steve. Justice?
A very important story. Recently, a researcher came from Oxford, was researching about Sharia application in Gambia, bearing in mind that we are applying wrongly against human rights. After completing his research, he told us that what he was said and what he's found on the ground is different. This means we need to be represented. We don't have people representing us in decision makers. We don't have people representing us in the lawmakers. That's why we have very good things that people don't know and cannot benefit from it. It's very important to give interest about this area because we all are serving human beings. We may have something more better than what we have already in our system that we believe it as secret things. But also I am telling you, we have in our Sharia and in our traditional, African traditional, it thinks that may be better, and when the world know it, they will take it as the best. To answer your question, what people saying, I think they need sensitization, because in the Gambia, the constitution describe everything. We have our own jurisdiction, and they have their own jurisdiction. I know in the communities, as Muslim communities, they like Sharia, but they have to know that Sharia are limited in certain area. Where Sharia limited, the statutory court cannot take it. For example, inheritance, divorce and marriage is only meant for the Sharia courts. So they are not controversial unless people think so or don't know. This is the fact on the ground. Wassalamu alaikum wa rahmatullahi wa barakatuh.
Si j'ai bien compris la question, d'après ce que Victoria m'a expliqué, la personne a demandé le droit des veuves, ceux qui n'ont pas de mari. Il faut savoir que ces droits, il y a des sociétés, il y a des structures qui sont là à Bamako, telles que ma structure qui est le WILDAF, dont nous assurons la prise en charge judiciaire de ces victimes en octroyant un avocat. Donc, WILDAF donne des avocats aux personnes vulnérables, aux femmes vulnérables qui en ont besoin par rapport à l'assistance judiciaire. Et pour, même si nous n'avons pas, parce que des fois, il peut y avoir une rupture de fonds, et même si nous n'avons pas de fonds pour assister à ces victimes, à travers l'assistance de nos parajuristes, ou bien à travers l'assistance de la clinicienne même, qui est au sein de la structure, assiste la personne jusqu'à ce que la personne puisse avoir gain de cause. Mais il faut savoir aussi que dans le système malien, il y a un défi. Le défi est que dans ce système-là, vous verrez que la femme n'a pas totalement la même mise sur les documents de son mari. c'est-à-dire la femme qui est mariée légalement à un mari, tu trouveras que la femme n'a même pas l'acte de mariage en possession avec elle. Tu trouveras que les biens que son mari a laissés au profit des enfants et pour elle, tu trouveras qu'elle ne connaissent même pas l'intégralité de ses biens. Donc tout ça là, ça pose énormément de problèmes. Avant de rassembler toutes ces choses-là, on peut faire des années et la personne, la justiciable, la survivante, elle ne va pas comprendre. Elle va dire que je n'ai pas eu justice, je n'ai pas eu justice, alors que ce dont elle devait apporter pour quand même qu'on puisse lui octroyer cette justice-là, tu trouveras que les documents font faille, la personne n'a pas de documents. Donc, c'est ces défis que nous confrontons et que nous sommes confrontés à la longueur de la journée. Et il faut comprendre que c'est une société patriarcale et c'est la polygamie qui est là. Et donc, si c'est la polygamie, tu trouveras toujours que ce sont les frères ou bien les parents du mari qui détiennent les documents. Et quand le monsieur n'est pas là, les parents, vu qu'il y avait déjà des conflits, parce que quand il y a la cohabitation, toujours il y a des conflits entre ces personnes. Donc, pour eux aussi, pour la famille du monsieur, pour se venger de la femme, ils ne donnent pas ces documents et au fur et à mesure, ils commencent à vendre les biens, les terres du mari en laissant les enfants et la femme de côté. Juste un petit exemple. J'ai eu un cas où la femme, elle était la troisième femme de son mari, mais le monsieur avait fait un premier mariage, c'était sous régime monogamique. Et la dame qui est la troisième femme est sous régime polygamique. Et quand le monsieur, juste une minute, et quand le monsieur est décédé, la femme est partie en annulation de mariage au tribunal. Et ça lui a été accordé. Et la dame qui vivait dans la maison de son mari avec les enfants, on lui a fait sortir avec ses enfants. Et la dame, on avait un projet, Wildaf avait eu un projet à exécuter, c'était uniquement gérer les cas pénaux. Et quand la dame, elle est venue, quand on l'a assistée, la dame était obligée d'aller dans un service social pour aller habiter. Et là, les biens de son mari, tout a été donné à la première femme et à ses enfants. Et elle est sortie comme ça, idem. Donc, c'est ce que j'aimerais dire comme exemple avant de terminer ma propos. Je vous remercie.
Yusra, please, you have the floor.
Okay, in Zanzibar, we do consider and give priority to those who cannot afford legal aid services, including the children in conflict with the law. We have the Zanzibar Law Society and other CSOs and other community-based legal aid providers who work collectively to expand legal representation and advice to those unable to afford legal aid services. We also support to children in conflict with the law. The Zanzibar Law Society and other partners are committed to ensuring that children who come into contact with the justice system are treated with fairness, dignity, and compassion in accordance with the Children's Act number 6 of 2011 and the International Child Rights Conventions. So the key initiatives here includes the free or low-cost legal representation, the reduction and waive of the legal fees, the promotion of diversion and rehabilitations, and the legal education and awareness. We also provide capacity building and collaboration, whereby the Zanzibar Law Society, alongside its partners organizations, continually strengthening the capacity of lawyers, paralegals, and community volunteers through training on child rights and juvenile justice, pro bono cases management, gender-sensitive legal aid, and alternative dispute resolution. So the collaboration between the Zanzibar Law Society and the CSOs-based legal aid providers represents a strong model of partnership in advancing access to justice by offering pro bono services, reducing legal costs for children, and enhancing legal awareness. These actors contribute significantly to the government of Zanzibar's vision of ensuring that no one is left behind in accessing justice, particularly the most vulnerable members of society. Thank you.
Thank you very much. And a big round of applause to my panelists. And I won't have time to, unfortunately, to go into a longer reflection in the end, trying to stick to what I was asked about on closing. But one point that did strike me today was the importance of context specific on working directly on the needs of the community. And I just wanted to take this opportunity to share with you a document that UNDP has released, the policy framework for justice and security programming, that is particularly relevant for development actors, for policymakers, for the ones here working directly on how to change laws, make sure how to work directly with policymakers into making sure that they are applied precisely into the context that are needed, and that my panelists here were so eloquent in sharing. So the one takeaway that I take from this, the second takeaway that I take from this conversation is that we do need more time for discussion on these issues. I hear you here on the plenary and the needs for us, and this just proves that the wealth of knowledge that we have here in this panel and across this room needs to be highlighted, and we need to bring these issues to light in other spaces such as this one. So with that being said, thank you very much for your time, and I hope that we can continue this conversation in the evening. But thank you very much for your time, and thank you to my panelists as well. Thank you very much. Thank you.
Good evening, everyone. So I promise you, after this session, you can all go. We'll have the cocktail, we have networking, we can interact in a very informal and social way. But before we leave, I think it's time to bring it all together and talk about what we've experienced today. We've had speakers from all over. We've had from Malawi, we've had from DRC, we had from Sierra Leone, Kenya, Tanzania, the Gambia, Mali. We've had from Senegal, Burkina Faso, South Africa, Uganda. We've had people from multilateral agencies, the UN. We've had from PALU. We've had from the Africa Committee of Experts on the Rights and Welfare of the Child. We've had from the Africa Commission on Human and People's Rights. It's been very rich. And through all of this, we've discussed one thing that has basically held us together, people-centered justice. And it's amazing to see how we can all relate to that topic and how, even though it sounds like a new concept, it's very familiar because it's something that we have been practicing. So I'm going to try and just summarize the highlights and then talk about two follow-up activities that are important to continue the conversation beyond today. So the first thing is, you heard in the very first session, you heard our colleague from Malawi who talked about how Malawi itself has been incorporating and collaborating with African justice mechanisms, particularly in the way the country has incorporated principles from the Commission's decisions into its justice system through policy articulation and judicial decisions. And we know of, one case which has been touted as a good example, a good model, where they implemented a decision from the Africa Committee of Experts on the Rights and Welfare of the Child. Then, of course, we listened to Sierra Leone, the idea of justice as an essential service that has to be universally acceptable and requires adequate resources and attention. And we also can balance that by looking at justice as a stakeholder activity, where every individual basically has a role to play in ensuring that, people-centered justice is well articulated. We're talking about exchange and learning across ECOWAS, and now with Sierra Leone holding the chairmanship of ECOWAS, this is something that we are really proud of, and we were very eager to support Sierra Leone in pushing people-centered justice through this position. Our colleague from Sierra Leone talked about linking data gathering to justice issues, on justice issues to peace building, and then scaling the lessons learned. And I'm happy to say that, at least I'm reliable told, I can't reveal the name of the donor, but there's a donor that is interested in supporting this. And this is something obviously that we hope that we're going to be working on. But this is obviously an area of interest, and we're keen to see it develop. We also looked at the introduction of mobile legal aid clinics and local dispute resolution mechanisms, connecting 40 communities in the Gambia, something quite innovative. We heard about the weakness of the African justice system in terms of its inaccessibility. In over 40 years, for 1.7 billion people, there have been less than 900 cases. And then most of the communications done by non-governmental organizations. To what extent do individuals have a right or are able to basically take cases to the African Commission? These are questions that, we would like to look into. And the follow-up activities, you see some of the ways in which we can address that question going forward. Then in the session that followed on data, and this, I'm a data person, I love data. I don't like to speak without having data. And one of the things, we always talk about people-centered, placing people and their needs at, the heart of the justice system. But how do you talk about doing this when you do not know what the people need or what their justice needs are? And this is where data comes in, because how do you prioritize what you do not know? And so you will see in many of the discussions that we had during that session, there were talks about justice needs and satisfaction surveys that the Hague Institute for Innovation of Law have been essentially carrying out in many African countries. And so we heard, about good practices in Senegal and in Burkina Faso. In Burkina Faso in particular, we heard about, even though 4 to 5% of people have access to the courts, most people go into the informal justice system, which keys very well into the last session that we had today. Most common problems are land issues. But then Burkina Faso is now using the data that they've gotten from these justice needs and satisfaction surveys to inform the development of policies and for reforms. And one of the things that we're doing at the African Alliance, especially in the Research, Data, and Evidence Working Group, is now looking at ways to support countries that want to begin to utilize the data. So how do you utilize data to inform policies and reforms? So we want to begin to support that. We also looked at the importance of gathering evidence of atrocities as a backbone for future action. how do you look forward when you can't look into the past? Ensuring that this is done in a way to capture the experiences of all groups, including vulnerable and marginalized groups who typically suffer the most during conflict. And so transitional justice, including truth-telling, memorialization, and so on, is now linked to the collection and gathering of evidence. We looked at the strengthening, and this came in through the questions after the session, the strengthening of the capacity of statistics offices. And when we talk about people-centered approach, we're not trying to create new systems. We're trying to adapt existing systems so that we're not spending money repeatedly where something already exists. So how do we collaborate with those offices to connect them better with the justice system? And so we heard a lot about the link between, empathy and how it should inform both data collection and the use of justice data. And I think this is something that has resonated with me, and I think I would take away from, this session. Then we went into the Justice for Children session, which was illuminating in many ways. We heard, and this was for me, a very profound statement when Honorable Amin talked about contextualization and adaptation of community-based solutions. So first of all, we have to understand in what context it happens, but then begin to see that even though our community-based solutions are recommended, but they are not static, they're dynamic. Law is not a static phenomenon. So we can also adapt them to our needs. And so understanding this is, I think, key to how we incorporate the customary and informal justice system. Justice must be connected to other sectors. It doesn't operate in isolation. Again, this was a key insight from that particular session. I like the way, when we talked about let's, especially with children, and I think it extends beyond children, but focused on children now, it's not always about punishment, and it shouldn't be. It should be about healing, reintegration, and rehabilitation. We already heard in this session about a customary and informal system, the Mato Oput system, that is being championed by organizations and being integrated into the formal justice system. And we heard, about how to begin to challenge the narrative that children should be treated as extensions of adults. We also heard a very good example of a practice of how to introduce diversion system into an African child justice system, and how it is important for all stakeholders to understand their roles. So diversion is not an end in itself, but a means to an end. The speaker, and that's Lady Justice Teresa, basically also talked about a pilot that I think we should all be interested in. Now, it's being carried out in Kenya, using data and research, and then customer and informal justice system, relying on stakeholders, and using court users committees to develop policies that are child-friendly. Let's look at how it works out in this pilot, so that we can begin to learn, within Kenya and then outside Kenya. Then Christian Nondo talked about the disconnect between the law in the books and the law in practice. And I like how Honorable Amin also talked about how to enable a trickle-down effect where you develop policies that will enable the law in books to actually operate in practice. Christina Nombo talked about paradigm shifts, also from punishment to support, essentially highlighting what Patricia had said earlier, and then importance of giving children a seat at the table to understand the justice system from their own prism and allow them to shape the system. So she wasn't only talking about it, she also demonstrated in practice what she's been doing. When we heard from Tara, and the child human rights activist, who really gives me confidence about how much more we can achieve when we involve children and make efforts to translate policies into child-friendly versions. Then, of course, the final session of the day, and I was really surprised about how animated and active that session was, despite us having been here, for this long. And there were so many things to take away from that session. The Kenyan example of the alternative justice system, an excellent example of integrating the formal and informal justice system. And then I love how Dr. Steve talked about seeing justice as a continuum. That's another thing that is profound and will stay with me. We heard from Justice Seka, who talked about the continuous reform of the CADIS system and how obviously it also works well with the Africa Commission because they are linked. And that's another example of integration of formal and informal justice systems. We heard from Ms. Aisha Diarra about strengthening the articulation between the customary and formal justice system by defining a legal framework which strikes a balance to ensure harmony between the systems. And of course, we heard from Ms. Said about extending legal aid services to rural areas and empowering paralegals to bridge the justice gap at grassroots level. So to take these conversations forward, I want to talk about two additional points. The first is we will be launching a report, and the report is titled The Principles and Opportunities for People-Centered Justice in Africa. We already have a placeholder, so very soon we'll send you the actual link to download, but you can already see a summary of the report by just, getting this QR code. It is a report that I thoroughly enjoyed, and I hope my colleague also enjoyed putting together. It wasn't only our effort. For those who are part of the Alliance, you will remember when we sought your input for the report. So many of your inputs did make it into the report, and we urge you to please download it. We will send you a notification once it's live. But I really want to highlight a few things in relation to the report. The first is that there are a few themes that the report aims to shape. Advancing justice for those furthest behind. We have a few working groups in the African Alliance, and one of them is we want to ensure that no one is left behind. The Justice for Children session is a subgroup within that working group. So there are going to be additional sub-working groups addressing other vulnerable and marginalized groups. And this segment of the report addresses this issue. They want to foster diverse pathways to justice, what we just concluded with in the final session. Then strengthening the role of data and evidence. We can't measure what we don't know. We can't really do or advance systems that we are not familiar with. So data and evidence is very important. Then, of course, preventing justice problems before they escalate. It is important that we pay attention to this. We also like to invest in frontline services and innovative delivery measures, delivery models. Now, I will stop here and I will still, tell you a bit more about this report, but I want to hand over to Honorable Lumbu, who will talk about the second activity that I was referring to as a follow-up. He's very busy with the ordinary session, and he has given us his time. And so I would just like to hand over to him to talk about the resolution. Thank you.
Yes, thank you very much, my friend. Interpreters are there because I will be speaking in French. Thank you very much. Vous félicitez d'abord tous d'avoir tenu jusque ce soir. Je pense que l'intensité du travail intellectuel qui est fait, et comme je vous ai vu le faire du matin jusqu'au soir, ça équivaut à 2 jours de travail presque. C'est comme des gens qui ont travaillé pendant 2 jours parce que vous avez travaillé de manière intense l'avant-midi et l'après-midi. Je voudrais d'abord vous féliciter pour votre engagement pour cette question de l'accès à la justice. Et toutes les idées que vous avez pu sortir ici et les recommandations sont bonnes. Je sais que l'Alliance africaine pour une justice centrée sur les personnes est encore une jeune organisation qui n'a pas 5 ans. Je crois qu'il doit avoir 2-3 ans. ou 2 ans, ou même une année, mais peu importe le nombre d'années, est en train de faire ses preuves en abordant une thématique aussi difficile, mais aussi important, parce que c'est une thématique qui touche le cœur du système. Je voudrais vous encourager à ne pas baisser les bras. J'aime bien le philosophe Descartes qui dit que lorsqu'un problème est grand, peut-être qu'on n'a pas les moyens pour le résoudre en entièreté en une fois, mais on commence à le résoudre par petits morceaux. Chaque fois qu'on résout un petit morceau, on finira un jour par voir l'ensemble des petits morceaux. Ça fera que le gros problème, finalement, il a été résolu, alors qu'au départ, on était dans l'incapacité de le résoudre dans l'ensemble. Je sais que le principal outcome de cette double matinée que vous avez eue, c'est une résolution sur la question de l'accès à la justice. Je m'engage ici solennellement à prendre en charge cette résolution et à devoir la présenter chez mes collègues commissaires au cours à prendre cette résolution sur l'accès à la justice et à la présenter à la prochaine session ordinaire de la Commission africaine que nous aurons en 2026, parce que cette session est la dernière. Hein? Elle est la dernière session ordinaire. Nous aurons d'autres petites sessions extraordinaires virtuelles, mais je voudrais que ce soit un bon texte bien préparé. Et si besoin, lorsque vous aurez terminé, c'est une suggestion que je vous fais, le draft que vous aurez déjà fait, et nous pouvons avoir une rencontre Zoom avec vous, au moins une fois, avant la session qui arrive. Ça vous fait une autre activité à mettre dans le plan de travail annuel pour 2026. Mais que cette rencontre Zoom se fasse avant le mois d'avril 2026, parce que our first session will be will be in April 2026. Comme ça, nous avons une rencontre Zoom, nous regardons la résolution, nous l'aurons aussi retravaillée avec les éléments de langage de la Commission africaine, parce que nos résolutions respectent une phraséologie logique, un séquençage de paragraphes et d'idées qui n'est pas identique et commun avec les autres résolutions qui viennent d'ailleurs de la CEDEAO, des Nations Unies, ou du Forum des ONG, du Forum des INDH, parce que nous avons notre propre langage. Mais peu importe, mettez-y simplement les idées que vous allez y mettre. Après, on aura une séance de travail par Zoom. Et la version qu'on aura trouvée, nous allons encore la retravailler en interne à la commission pour que je puisse présenter cette résolution en 2026. Sinon, pour le reste, vous pouvez aussi compter sur moi s'il y a d'autres activités sur l'accès à la justice. Je suis disponible. J'ai maintenant un peu plus de temps pour travailler pour la justice, les représailles contre les défenseurs et les défenseurs eux-mêmes, maintenant que je ne suis plus membre du bureau. Je vais m'arrêter par ici et retourner dans la salle parce qu'il y a encore des collègues qui présentent leur rapport d'activité. Et j'espère que d'ici là, nous allons vous revoir. Je vous remercie tous d'avoir été patients. Merci.
Thank you very much, Honorable Commissioner. As you're leaving, I'm sure you can hear my words. We do commit to working with you. We will share the resolution with you in its draft form and work with you to ensure that it's in the perfect shape to go before the Commission next year. Thank you very much. So the Honorable Commissioner has talked to us about the second activity as the follow-up, from this workshop, from this event, because we want to keep the conversation alive, but we also want, a strong instrument that can be utilized for advocacy and also to shape our legal conversations in our respective countries. So this is something we're going to be working on at an alliance level, and we'll carry you along so that everyone is part of this resolution that we aim to prepare. So going back to the report, one of the things I want to really highlight, from the report, and it came out in the last discussion, is the fact that people-centered justice is not new in Africa. Already in many of the discussions we heard about the Ubuntu system in South Africa, we heard about Mato Put in Uganda. In this report, we talked about many others. We talked about the Palava Huts in Liberia, the Akon traditional system in Ghana, the Kikuyu Council of Elders in Kenya, the Chaga People's Customary Courts in Tanzania, the Gada system of the Oromo people in Ethiopia, to mention a few. There's so many more. It just shows that we have already been imbibing people-centered justice principles as far back as we can remember. And somewhere along the line, we derailed a bit. It doesn't mean that these systems are also perfect. This is where, what Honorable Amin said about contextualization and adaptation, this is where it comes to play. Because we always also have to keep adapting the system to modern realities. And so what we see is a need for us to understand that this is not something new that is being pushed. This is us basically going back to our customary roots and then promoting something we're already familiar with and something we have been utilizing in the past. And so what makes these practices even more remarkable for me is their resilience, the fact that they've lasted, through centuries. They're still alive today in many parts of Africa, adapting to modern realities while preserving their core principles. And these customs are not just relics of the past, they're vibrant, they're living tradition that continue to serve as effective mechanisms for justice and social cohesion. And of course, we have to continue to align these customs with modern justice principles. Many of the traditions that I've mentioned resonate deeply with contemporary ideas of participatory, restorative, human-centered justice. They emphasize active community involvement, forgiveness, and healing, values that are central to the global movement towards a more inclusive and humane justice system. And these customs, many of them, I'm not saying all, uphold human dignity, respect for persons, social reconciliation, and they're still relevant even today. Thus, I want to urge you all, again, to not just see the customs as cultural artifacts, but as living, breathing sources of justice. They are pathways towards a more inclusive and healing, human-centered Africa. And by valuing and strengthening our indigenous practices, we can foster societies built on trust, reconciliation, and mutual respect, foundations that will sustain us for generations to come. So I thank you for being patient. This is 6 p.m. And I think we can bring, oh, sorry, I'm operating on Nigerian time. This is 5 p.m. and I'm happy we can bring this workshop, this event to a close. Thank you very much.
Thank you all. I won't add anything further to Boya's excellent closing, just obviously to appreciate your time and attendance and participation. And now we move to our next and final step of the day, which is please join us in the lobby. We'll have some cocktails and some snacks and some eats where we can continue our discussions, continue to network, and, which is one of the benefits of some of these in-person events. So please do join us, and as we close the day out, thank you so much for your time and participation. Good day.